everybody. We got day 9 in the bag. Life is flooding back. The glorious sleep has been so rejuvenating. I feel like $1,000,000. I got 5.5 hours last night, and it felt like about the most luxurious sleep I've had in quite some time. So today, boy, today, the only way I could really think of to sum up today is that we are now entering the street fight phase of this trial. The case is turning to Richard Allen. So we heard about his initial interview with police, his volunteering to come forward, how it that vanished into the deep recesses of the file system in the investigator's office, and how it was subsequently rediscovered years later. The way that the law enforcement officers focused in on Mr. Allen and made their case against him. And boy, the defense came out swinging, taking hard shots at not just what they have against Mr. Allen, but most significantly, everything they do not. So let's just get right down into it, shall we? It was kind of cold this morning, getting pretty cold. When we got into the courtroom, Judge Gohl, she doesn't every day do the admonishment of the jurors or kind of question them about, have you been exposed to media? Have you spoken to anybody about the case? Things like that. She has only done that on the day following an evening where she allows the jury to have contact with the outside world. So we all kind of learn about it because she lets us know you were able to speak with your families last night, check your emails, things like that. Of course, under the supervision of the court's bailiffs. But because they've had that outside contact, she gives them those admonishments, or they're not really admonishments, I guess. She just asks them to confirm that they haven't read anything about the case, done any investigation, and so forth. And of course, everybody is indicating that they have not done so. Those of you on the Mr. Rosy fashion watch, he went very classic today. It was a dark gray suit, not as dark as charcoal, but still a much darker gray tone. He wore a nice white shirt and a tie. It was hard for me to really nail down the color. It wasn't quite a cobalt blue, but it also wasn't quite a navy. It was kind of somewhere in the middle. It was like a bright navy blue color. Very, very attractive tie. Really enjoyed that one on him, but understated relative to some of the other things that we've seen him bring into the courtroom. Our first witness of the day was Kathy Shark. She is a longtime resident of Delphi. She's lived there for 40 years. Came after, well, she worked for Purdue. Back up. She went to Purdue, graduated, and when she came to Delphi, she worked at the Department of Child Services. So she works with the foster care system, basically. Through that, she developed lots of contacts with local law enforcement. Those are the folks who are usually in the position of removing children from unsafe homes. So there is a lot of contact there, and had a lot of contacts. When the murders had happened, she was out of town on vacation. She had retired at this point in time. She was no longer actively working for DCS. She followed the case from the first press conference. The former prosecutor, she indicated she knew well. So when she got back into town after her vacation was over, she contacted the prosecutor, said that she wanted to help. And beginning of March 1st, very first day of March in 2017, she volunteered for the investigation, and which she is continuing to do up until the present time. When she first started in March 2017, I'm going to mention that again just because the date is going to be important for reasons you'll see as we go on. So, few weeks after the incident has taken place, a couple weeks, and the investigation has already gone through some early steps. So, her first job when she started volunteering was basically as a receptionist. They had set up a command center in a separate building. Somebody had a vacant building basically that they allowed them to go ahead and move into, because with the volume of police officers and people coming through and stuff like that, it was overwhelming the city building that they were in. So they set up in a separate building. She basically started off as the receptionist. So she would take tips. When people would come in with tips or email tips, she would refer that along to the detective. And there was an information sheet that she would create that contained the name, just how to identify them, contact them, and a summary of what they wanted to communicate about the case. She estimated there were about 50 or more law enforcement officers working on the case at this point in time, but she did not keep track, really know who worked on what. At this point in the investigation, her contact with the information about the case and kind of what was going on behind the scenes was pretty limited. She was really front of house. Later on, she was given some more special duties. So the first assignment that she mentioned was she was given numerous banker's boxes that were all full of investigative reports. So just police had followed up on leads. They had written summaries. They'd spoken with people and described that in their reports. Boxes and boxes of these this type of information, and she was asked to organize them in a way that was going to make it more accessible. So she went and got some filing cabinets and was created a system to label these reports, stick them in their own little file folder, and had a labeling system where she would name the file based on, is this a person, a witness, is this a person of interest, or whatever. So names basically, and then containing the report that related to that individual. She was asked specifically not to go in and get into the details of the report. And she ultimately filled about 5 filing cabinets, multiple drawer filing cabinets full of these reports. So that was basically everything that she did with the folders at that time. She just created an organized system, store it so that it's accessible and people would be able to find things. They did not. This just kind of brought this up. Interesting. She mentioned there was another coworker that worked with her on that. They did no background check on anybody. There wasn't any background check. It was just very much a trust system because they had known her. She'd worked with them for years. So no real vetting of the people who were doing this type of work. So sometime after the filing system had started, the tips had begun to slow down. Like I'm sure you can imagine, there's a huge flood of them at the beginning. And as time goes on, it starts to reduce down to more of a trickle. So after she finished the filing system, she was then given this new responsibility of entering these narrative summaries into a database. Just to kind of make everything more accessible and able to cross-reference a little bit more efficiently than just a filing cabinet is able to do. So what she would do with this, the summaries would be in a report. It would just basically say what happened, who was talked to, who was contacted, if there was evidence. I mean, just whatever the officer did that put in that report. The way that the database was organized was that the leads that they got, they would organize the case in leads. Each one was assigned a specific number, a unique identifying number, and then the leads would be put into what she called this a covered lead section. And so the covered lead was just basically something that somebody had responded to, and that was to distinguish it from a lead that was not, basically they didn't do anything with it, they didn't do any follow-up. So these reports were all generated from leads that were covered, meaning somebody took some type of action on it. The system was special just for this particular investigation, for the Abby and Libby investigation. It wasn't like part of the broader police department or anything like that, the sheriff's office as a whole. After she finished getting the leads in, she was then asked to start entering the tips in. And so the tips would be forwarded to her, typically by email. She was also part of the Abby Libby tip line, so that the leads would just go straight to her. She said that they were basically they were getting tips by email. I don't think they were maintaining a phone at this point, like a specific phone number for tips, but they had an email number, and so those would then go to her. So at this point, they have moved out of this building now and gone back into the city, the city building. She identified who the people involved were, the unified command who was running the case. They're the ones who gave her instructions. She identified now Sheriff Tony Liggett as the main go-to for questions. So at some point, just like the tips fell off, the law enforcement officers also began to fall off. Fewer and fewer of them were still involved and assigned to this particular investigation. And so she described the investigators as kind of distilling into a more cohesive group. But nevertheless, she was, at this point, she didn't need to be a receptionist anymore, so she's not front of house, but she's now back of house. She's kind of behind the scenes in a back room, not attending their meetings or anything like that, but doing largely administrative work. She brought the file cabinets with her. She says it still exists today. She's very protective of the file cabinet. So she, through this process of running the tip line, taking the tips, she started to enter the tips into the database as well. About September of 2020, she was asked to start scanning the information from each file in her file system into the database. And so the tips were already in, and a majority of the summaries were already in there, but there were other documents in this filing system that would need to be entered. And obviously the ones that hadn't made it in the first place, they would need to be entered as well, just so that then the database is fully comprehensive. It captures every part of the investigation. She said that process took her about 2 years. She did not, according to her, read every report while she entered it. So still, she's clearly getting more and more access to details about the investigation, but she is not primarily focused on becoming familiar with the details of the case. The investigation moved again because they needed some more room. Again, she brought the filing cabinets with her. She says they were mine. They were mine. They were her filing cabinets, and she was very protective of them. When asked to estimate how many tips she herself had taken and processed into the database, she said it was a little bit over 14,000 tips the last time that she checked. The database had a system to be able to identify who had processed the tip, so she could go back and search that by her name, and according to her, that her name shows over 14,000 tips processed. Massive volume of information that was coming in for this investigation. So in the process of moving from the city building back to this new location again, she was taking the materials with her, and she discovered a box that had gone into a desk drawer during the process that she was scanning. And in the course of going through this box, she realized that she was seeing handwritten tip numbers. So what this told her was that these preceded the creation of the database, because the database would automatically assign the lead number, the number to the tip. And she needed to think of a way to be able to reconcile these handwritten ones that preceded the automatic assignment before they had this database system in place. So these tips then, because she was the primary one in charge of creating and maintaining these database, these tips were things that had been written out before she had come onto the investigation. Remember, she came on March 1st. Investigation started on February 14th. So for about that 2-week period, there were things that were handwritten that she had not. These particular ones apparently had been put to the side, somehow ended up in this box that ended up in her desk. So when she was going through this box, she found a lead sheet. And the lead sheet stated that on February 16th of 2017, Richard Allen had self-reported being on the trails between 1:30 and 3:30, and he had seen 3 girls. So, although, of course, it's not her job to read through and be familiar with the details of the case, and at one point she'd even been specifically told not to, obviously over the course of this she has. And she indicated she had previously read that a young girl had seen a man on the trails at the same time in the place that he had reported being. And so that seemed to her like a possible connection. And it caused her to take that concern to go check it out in her file cabinet to see what she could find. She says she doesn't know. She has no idea how that lead ended up in that box. She had apparently filed a lead like this back in 2017, but she didn't remember that. So this particular one that she had created this particular one had been created back in February 2017 before she had started her assistance with the case. So she assumes that what was in the box is just things that had come in before March when she started. She had never prepared written sheets in her part of the investigation, and so that's part of how she knew that these ones pre-existed the database. The lead sheet listed the name of the person as Richard Allen Whiteman. So Whiteman was listed as the last name. She found Richard Allen Whiteman in the file cabinet. And then inside that file folder, she found there was a narrative summary that had been entered into the database stating back in February, stating that Richard Allen had been interviewed and the tip numbers coincided. So she realized that the Richard Allen Whiteman and the Richard Allen, these were the same. There was a connection there based on the narrative summary that she found in the file. The lead narrative that she got had a mark on it indicating it had been cleared. And so her coding system had marked green on cleared files. She is not the one who decided if tips were cleared or not, or who followed up or anything like that. So when she found this lead sheet in this file, Tony Liggett was at the same location as her, so she took the information to him. And then based on ascertaining that the original name had just been misnotified as Mr. Richard Allen Whiteman, she went ahead and changed the name in her own file cabinet to Richard Allen. She discovered that document, that tip sheet in the file on September 21st of 2022, which she remembered because it was her deceased husband's birthday. That will stand out in your mind. That was all that she testified to. Mr. Baldwin did the cross-examination. The documents, the contents of that file folder, they were admitted into evidence. More horrifying stuff for me because, once again, it's all hearsay. Not only is it all hearsay, this is probably testimonial hearsay. This gets the highest protection under the Confrontation Clause. There's a U.S. Supreme Court case, Crawford versus Washington, that established this rule that basically testimonial hearsay, if it is out-of-court statements that were given for the purpose of assisting in a police prosecution, then you have a near absolute right to cross-examine that person, and that information can't be it can't be brought into court without the person who provided it being available for cross-examination. So I have a little horror. I mean, I've mentioned this before. I have a little horror every time these reports get admitted into evidence, but there was no objection. But Mr. Baldwin did start off by pointing out that she has no idea if the information that's actually reported on these papers is accurate at all. There could be mistakes in it. Obviously, it seemed that Richard Whiteman was a mistake. It was not the proper name. She said, it wasn't me who made this mistake. This was a theme throughout the day. It wasn't me who made that mistake. The initial page that said cleared, the entry was under Richard Allen Whiteman, and so she did not know who did it. She didn't know any of it. She didn't know who did the tip. She didn't know who marked it as cleared. It had all proceeded when she started. We identified the database as Orion is the name of the database. So she clarified that yes, tips and narratives were separate things that she was putting into Orion, and she would receive the tips and enter them. The narrative summaries were the reports that the officers would make when they had gone in and followed up with somebody. So these were separate things. The tips and the leads, they were going into the database. They were getting assigned a lead number. But then the reports were coming in, and the reports are just your standard paper reports. So that's why she had gotten into that organizing system of making sure that the narrative summaries were organized in a way that they could be accessed. So then ideally, they would be able to correspond those narrative summaries with the tip that's there in the database. So if what would happen, the tip would be entered, and the tip would either be left as a tip or it would be determined to be a lead. And so if it was a lead, then it would be assigned that in the database, and then that would be followed up on by somebody. There would be a process of somebody who would follow up on that lead. They would make a narrative summary, bring it to her. She would then enter it into the database. And that was essentially the process. They would follow the lead until there was no more following, and then they would produce their report, give it to her, and that lead would then be cleared. As far as how everything ended up in the file, she didn't know, just that it was there, and that was all that she was able to say. There was no other tip. This was the only tip that they had received concerning Richard Allen or Richard Allen Whiteman. So this self-report, as they characterized it, him volunteering information to the police, is the only way that Richard Allen came to their attention. Nobody else had raised any concerns about him whatsoever. I don't want to say this is remarkable, but just given the volume of the tips and the way that they've described this investigation, where pretty much everybody under the sun was, especially like after the bridge guy photo was released, everybody under the sun was like, my neighbor, it looks like bridge guy, the neighbor that you hate, that, they're kick your fence or whatever, everybody is trying to identify people that they think maybe look like him, or spend time at the trails, or just could have information, whatever. So all of that information coming in, despite that, and despite what the state now wants us to think, that Mr. Allen looks just like bridge guy, nobody came forward and said, hey, that guy that works at CVS, he kind of looks like bridge guy. Nope, never came to their attention. So, going back to how what caught her attention was the timing that he had identified in his statement, the fact that he was out on the trail at the time, reported seeing the girls, and that corresponded with the information that they had from the girls who believed they had seen Bridge Guy. So that was the connection. Following up on that, though, she did not remember if the bridge guy, had been reported as tall and muscular. We're going back to the details now of exactly what that tip was about, that information about who Bridge Guy was and what he looked like, to emphasize that he does not resemble Richard Allen very much. So she was very emphatic. It was just because of the time. It wasn't because he fit the description. He didn't fit the description, although, you know, she didn't know that. But she was just very focused on the date and the time. The report about Richard Allen and that contact, it didn't include a description of him, but they did have his phone number, his address, contact information. Mr. Baldwin was asking about the fall off because he's asking about the FBI. He wants the jury to hear that the local police booted the FBI off. And she, however, was not sure about the FBI and that she wasn't privy to the inside details, not part of the investigation. She did not know what the total number of tips were that were processed through the database, just that she herself had processed about 14,000. She said some would be things like, like Bridge Guy looks like my neighbor and stuff like that. She conceded that lots of people looked like Bridge Guy in the tips. They got a lot of tips about people looking like Bridge Guy. She did not remember any tips about a guy in his 20s with brown, fluffy hair. This is evoking that description that Betsy Blair gave about Bridge Guy. She said also that she would probably remember a tip about a man walking down the street covered in mud and blood, but she did not remember receiving any such tip. Mr. Baldwin asked if at this time, the time that she discovered this tip in September 2022, was Mr. Liggett running for sheriff then? That got objected to as being outside the scope of direct, and that was sustained. We saw a lot of objections today. I have some thoughts about it. I'm not going to get into the weeds about that right now. But just I made a lot of notes of objections, so be prepared. Those are coming. So the bottom line about this tip was that Richard Allen had volunteered that he had been out on the trail, and that it was just he had come in himself to provide that information from the police. She acknowledged that. And that was essentially the whole nature of the tip. She did not start entering the tips until they had moved into the city building. And so that was about a year after the investigation had started when she began to process the tips into this Orion database. And so there were lots of tips that had been entered before she started. She did not read all of them. So she wasn't aware about things like if people had, police had spoken to people at a roadblock out in the trails, because somebody else had probably already entered those. If there was a narrative summary from the part preceding her time on the investigation, then that she might have entered into the database, but not the tip. But for whatever reason, it seems like this Richard Allen narrative summary, she didn't enter. It was already in there. Somebody had entered it. It was cleared, and that was outside of her purview. So she's not the one that managed the original tip. She's just the one who found it later on in 2022. We had a lot of jury questions today. In this first witness, there were, I believe, 2 jury questions that were presented, but only one that was asked. And that question was, how did you determine that the name was incorrect? So she clarified that when she had the tip for Richard Allen Whiteman, she went to the file. The file was also under Richard Allen Whiteman, but then the narrative summary that was inside the file showed that his name was Richard Allen and he lived on Whiteman Drive. So she put two and two together that that's how the mistake happened. Somebody just, picked his address, his street address, and somehow turned that into being his last name. And then that mistake got perpetuated from the lead sheet into the file name. And the only reason that she had pulled the file, that it came to her attention at all, is because she had just happened to come across the tip sheet in a box in her desk while they were in the process of moving house. Our next witness was Daniel Dulan. He was the conservation officer with the Department of Natural Resources he did the original interview with Mr. Allen. So gave us a little bit of his background. He is a DNR officer, but they are still LEOs. They go through the same training and so forth. Their specific purview is to enforce the law on DNR property. And so, yes, they enforce a lot of hunting and fishing regulations and things like that, wildlife laws, but they basically enforce all the laws on their property. So they're the same as other law enforcement officers. At the time, in February 2017, he was out when the incident happened, but on February 16th, he came back and offered to assist with the investigation. So on his first day back, he went to the command center. He offered his services. He got briefed on the basics of the case, and then he just followed up on whatever they would ask him to do or leads that they wanted him to follow up on. So then on February 18th, he started following up on leads. The way they would do this is they would have a morning briefing, and the lead sheets would be printed out. They'd be distributed to the officers at this meeting to follow up. They were to make contact, preferably in person, to find out where the person was, how to contact them, where they were at the time, and why they thought somebody might have called them in about the tip. The lead sheets, he says, were very basic. It had the name, it had a way to contact the person, and then just whatever the reporter had said about why the person was pertinent to the case. He described some leads as complex, that they would need to do follow-up. Some were very simple. They would get a lead, they would go talk to the person, that would be the end of it, and it would be closed out. But some would do some efforts to verify, just other type of follow-up, and they would follow that lead until it ran out. So he got the lead sheet about Richard Allen, and he was followed up on that. He was listed as the source. Richard Allen Whiteman was listed as the source. So on February 18th, he got the lead sheet. He contacted Mr. Allen by phone, which was listed there. He had left his number for them. So he spoke with them. He said that his preference was to meet at his house, or second choice would be to meet at the law enforcement office facility. So he said that he asked if he could come out to Mr. Allen's house or meet at the law enforcement office, and said that Mr. Allen wanted to meet at the grocery store parking lot, and that stood out to him because his house wasn't far away. So he did not recall using, what name he used when he called. He doesn't know if he called him Mr. Whiteman or whatever, but ultimately he did determine that the guy's name was actually Richard Allen when they met in person. So they had a short conversation there in the parking lot of the grocery store, and Mr. Allen said he was on the trail between about 1 and 3, which he noted was a change from the original tip of being about 1:30 to 3:30. He wanted to find out if Mr. Allen had seen anything on the trail or anything suspicious. So Mr. Allen said he'd seen 3 girls at the Freedom Bridge at the beginning of his hike and nobody else. He said he had parked at the Farm Bureau building. Now, this officer was not sure if he had actually used the expression, the Farm Bureau building, or if it was just a mistake that he made at some point, maybe in writing his report or taking his notes or something. But it became clear as they talked about where exactly is this, that what he meant was what they refer to as the old CPS building. Mr. Allen said he wasn't paying attention to anybody else on the trails, or just, wasn't paying attention during his walk because he was looking at a stock ticker on his phone while he was walking. During his interview, he would take notes on the back of his lead sheet. He did not record this interview. It was just something that he noted. He didn't have an explanation for why he didn't record it. He said this is one of the first leads that he conducted. He did have a voice recorder that day. He did record several of his leads, but he said he has checked everything but found no recording of this interview with Richard Allen. He asked for Mr. Allen's phone, the information about his cell phone. He had it with him. And so he gathered what he was able to from that phone, including the MEID number. So we heard about that yesterday during the not so good moment for the defense, where we learned that they had the MEID number for this 2017 phone. They were able to compare that against the devices they seized from his house, and the 2017 phone was not among those. I had thought it seems like the kind of thing they would get from a search warrant, but no, he got it way up at the beginning here through this interview. He then took his notes and typed that into a document summary, just puts it into a Word document. He ran Mr. Allen's driver's license, printed out his picture, and he puts a little package back together with all of that information, the original lead sheet, his document, his summary, his narrative summary, and the driver's license and photograph. Staples that up, submits it in. And that was his normal practice. The phone information he provided to the forensic investigators, and that was the end of his role in the investigation. He did not follow out on that lead anymore. In September of 2022, he got a call from an investigator asking if he recalled having conversation with Richard Allen. He didn't remember his name, so he said he'd look for it. He had a binder of these tips that he had followed up on there in the DNR office. So he put in the name, and it brought up a Word doc. I think he looked for it. This was a little bit off. He said he'd look for it in his binder, but then he's in the computer typing the name into the search bar. In any event, whatever, it brought up the Word document that he had used to type up that narrative summary. So he knew that they had interacted, and he was then able to go find the packet in the binder. And then that brought it back to him about the details of that conversation. So he met with the investigators. He brought him the documents that he had. He did some then further investigation on Mr. Allen using the DNR resources that he has available. And specifically what he used is the point of sale system that they have for outdoor licenses. You want to buy a hunting license, a fishing license, a camping license, firewood, whatever you get from DNR. You can do it through their point of sale system, and that provides a little bit more information besides just their name and address. You also get their height, their weight, both So he searched for Richard Allen, and he found that fishing licenses had been issued to Richard Allen and his wife. And that had identifying information in it, including, again, the height and weight and the date of birth. He's able to view the licenses issued through this point of sale system. You're also able to get some very detailed information from the administrative side of the system, such as the credit card that's used to purchase the licenses, the IP address of the device that contacted the point of sale system, changes to the email, and in this particular case, what he called out was a change in the physical profile. So according to Officer Dulan, in April 11th of 2017, in the course of, I think presumably in the course of buying a new license, the height of Mr. Allen was changed from 5'4" to 5'6". So his weight also went down by about 15 pounds. This in and of itself, he acknowledged sometimes people do that. They change their information like that. He thought it was uncommon to increase height because at our age, usually people get shorter. It's much more common to change the weight side of that information. And also the date of the change. That stuck out to him. He thought, that's notable. He is the first person to make an in-court identification of Richard Allen. He identified Richard Allen as the person that he interviewed. So finally, somebody has connected the actual defendant in the case to something, some part of the testimony. Mr. Rosie did the cross-examination. Mr. Rosie was really on fire today. I've said before, this man is a beast at cross. He is very, very good. He is very good at this skill. First thing he elicits is that it was Mr. Allen who had reached out to law enforcement and that he cooperated. He was not sure if Mr. Allen had called in, but he then noted that the tip sheet says that is what happened. He didn't email, he didn't text. He picked up the phone and made that phone call. Confirmed that Mr. Allen told him voluntarily he was on the trail. He left a phone number that was accurate to be able to reach him. He met him at the grocery store. This was the same day, within an hour or two of that initial contact. He showed up on time. Mr. Rosie pushed back on this idea that this implication that came out on direct that Mr. Allen didn't want to meet at his phone or at his home. They wanted to suggest that, maybe he's trying to hide something, trying to distance them from his home. Mr. Rosie elicited, actually, it was possible that Mr. Allen had just told them he was on the way to the grocery store and, said it wasn't uncommon for people to not want to meet at home, but in any event, it kind of, the impression that I got, the position that the defense is taking on this is that he just told him he's on the way to the grocery store, meet him there if you want to meet him like right now. That would be the fast way to meet him. Otherwise, if he's going to be back home, that's not going to be till later on. Just the impression I got. But definitely the officer confirmed that Mr. Allen just told him he was on the way to the grocery store. He didn't say, no, you can't come to my house. There are only 2 grocery stores in town, and people often frequent the grocery store, common place to go, common place to run into other people. So just recapped again that the meeting was brief. He said he was on the trails between 1:30 and 3:30. Now, this became a little bit of a back and forth because he didn't say the exact time that he got there, and he didn't say how long he was there. Officer Dulan assumed that when he said first 1 to 3 and then changed it to 1:30 to 3:30, that meant that was the entire time that he was on the trail. But it seems like a reasonable interpretation of saying that you're on the trails between these times is that you were just in that time frame on the trail at some point, and you don't necessarily remember exactly when, but just sometime between these times. So a little bit of a dispute in terms of exactly the interpretation of that information that was provided to Officer Dulan. He said there was nothing unusual about Mr. Allen when he met him. He was not armed. He did not take note of what he was wearing or his overall appearance. It was a 5 to 10 minute conversation. His notes on the back of the tip sheet, he said he didn't know what happened to them. Mr. Rosie was asking, wouldn't this be the best evidence? Wouldn't the notes be the most accurate? These were objected to as improper characterization, and that was sustained. He's not allowed to ask the DNR officer if the notes he took during the interview are the best evidence of what was said in that interview. It's not counsel characterizing. He's asking the officer, the witness, if that would be his characterization. These are some really bizarre objections that are being sustained in my eyes, but they were. So he was not allowed to ask that. He did not specifically recall anything that was in his notes besides what he had put in his summary report. The reason he remembered the interview is when he was reading through the summary and got to the part about the stock ticker. He said that's what triggered his memory about this interview and so reminded him of who he was talking to. He had taken a deposition in March 20th, probably earlier this year. And at that time, he said he had no independent recollection of what Richard Allen said. So this was an attempted inconsistency. If you remembered the part about the stock ticker, that's remembering something independently that he told you, and that's not what you said. In March, you said you didn't remember anything. So he backpedals on that a little bit and says, well, he just meant he didn't remember the entire conversation. Didn't have an independent recollection of the entire conversation. He had already spoken to Mullen, investigator Mullen, at the time of the interview, and he did not know Richard Allen before. He didn't reach back out afterwards. The wrong name was provided to him. He didn't make that mistake. Theme of the day. He didn't make that mistake. Somebody else made that mistake. He corrected it. He doesn't know what Mr. Allen told the person who took down the information or if they entered the name incorrectly. Mr. Rosie asks, you're not saying he was trying to hide, trying to conceal his identification? This was objected to. So that was initially, that was sustained. He tries again. It's sustained. Mr. Rosie at this point now, he's getting annoyed that he's not being allowed to ask this question. He's like, you said you changed his ID on his license, and it's relevant, because they're trying to imply that he's doing this stuff deliberately, that he's deliberately giving them false information, trying to conceal it and so forth. The judge then at this point said it's asked and answered and sustained the objection. This was very bizarre. The man never answered whether he was saying he thought Mr. Allen was trying to hide his identification. He noted that Mr. Allen was willing to give him the phone information, his identifier, all of that. He did not ask what Mr. Allen was wearing on February 13th. He didn't ask what he was driving. He didn't ask about, or he noted the comment about the parking at the old Farm Bureau building, but he was not sure if it was Mr. Allen that used those words, so reiterated that. Through the process of describing the physical location, he just is 100% confident they meant the building that's north of the Freedom Bridge, and that they cleared up between themselves what was meant about where he was. He conceded that he does not know who entered the height and weight information onto his fishing license, that it's possible online to get a license for someone else. In fact, at the time in 2017, somebody had purchased licenses for both Mr. Allen and Mrs. Allen. So he knew that the credit card was used and that you need a username and password. And again, just noted the change was from 5'4" to 5'6" and was a 15-pound weight change. He then, we got into this mud. We got into a little bit of quicksand, because he brought up that in the point of sale system, you can go back and you can look at the historic records. So previous licenses that the people had gotten. And they looked all the way, he had historic records all the way back to 2005. Conceded that he saw many other references to him being 5'6". The change that was made in 2017 was consistent was consistent with the prior licenses. But then he gave this explanation that he looked into how the point of sale system works, and that there is a header for the license that's updated every time you change your license. And so if you go in and you make this change, according to him, it changes the heading for all of the old licenses. And so if you printed out those old licenses, they would all say the most recent entered height and weight. So it's like this strange sort of auto-population of prior documentation with this newly entered information. He conceded he had not seen Mr. Allen's actual historic licenses that had been issued, just the information that's in the point of sale system. And he had said before, he had conceded he had no reason to believe that Mr. Allen was trying to be deceptive. I think this was during his deposition, but it wasn't completely clear. Mr. Rosie elicited that he had many tasks in addition to following up on leads and interviewing people. He was also given cell numbers associated with the towers, with the tower pings, tower information, that he followed up on dozens of those leads, and lots of those people had reported being around the trailhead on February the 13th. The witness makes sure that we know that the area at issue where the tower had captured these numbers was bigger than the trailhead. It included some people that lived nearby, some people who were in the vicinity of Heartland Highway. So it wasn't just, people who pinged right there at the trailhead. It was a little bit of a larger area. Didn't say anything, of course, about Mr. Allen in this context. Nobody brought it up. It was just left unsaid, but it's certainly the question that comes up. Okay, we're talking about following up on these pings, and you got the cell numbers, and didn't hear anything about Mr. Allen's number being on that list. We heard there was no other tip, no other lead about him. He hadn't come to law enforcement attention before. So it seems like the conclusion we are to draw from that is he didn't ping off the tower. He also canvassed the crime scene. He was out there numerous times throughout the week. They were out there, like they had the dive. He described they had the dive team walking out there looking for evidence. They were out there in the wooded areas. He, of course, being a DNR officer, spends lots of time in wooded areas and by creeks and stuff like that. The first day he was out there, he said, was February the 17th, so just 3 days after the incident. And while he was out there, some items caught his attention. It was some sticks and branches that were in a pile in about a 4 to 5 foot area, and they had blood on them. So, knowing that the scene had been processed and had been released, he suggested to the CSIs or somebody that, or didn't necessarily suggest you should come get these, but just relayed to them that the sticks are still out there. And so he acknowledged the crime scene techs had been back out there several times, but eventually, nevertheless, after he relayed this information, they eventually came back and collected them. He acknowledged the scene had been released at this time when he went out there on February 17th, but there was still crime scene tape around the area, but there was no security at all. He had not, although he does for his work spend time in the woods and by creeks, he had not previously been in that particular area. When he went out there, he immediately noticed deer stands. So he was able to recognize that people had been out there hunting. He was asked if he believed that people hunt out there. Mr. McLeland objected to that as speculation. That objection was sustained. This is an officer whose specific job is like to find illegal hunters, to find poachers. You need to be able to spot signs that people are hunting places. Like if there's anybody who should be able to give an opinion on whether people are hunting in an area, it's probably a DNR officer. And we've seen so much, and we're going to get into even more of this skilled witness testimony where these people who are not special whatsoever get to offer their opinions as if they were experts, even though, they're not experts. They're considerably less than that. So seeing a lot of this come out already, but when it comes to the DNR officer, when the defense is questioning them, no, it's speculative. That objection is sustained. He conceded that it was not uncommon to find rounds on the ground in areas where people were hunting, but he did specify, but rifle cartridges or 12 gauge, 12 or 10 gauge shotgun shells, something like that on the ground, that wouldn't be particularly unusual. So really trying to distinguish the small caliber handgun ammunition that was located in this case. But he also conceded people in the countryside often have handguns. There is no prohibition in the state against going out and shooting them. He acknowledged that fishermen often carry handguns with them. He acknowledged that Sig Sauer was a standard issue firearm in 2017, and he acknowledged that Smith & Wesson is a very popular manufacturer of ammunition. On redirect, Mr. McLeland went back to this issue with the fishing licenses because Officer Dulan acknowledged he doesn't know who purchased it through the point of sale system. You can't specifically say who's at the other end of the computer, but they do have information. So they elicited that information about what credit card was used. It was Richard Allen's credit card for both Kathy's license and for Richard's license. They are both the same IP, and they had to use the same username, but he did not recall which username was used. So we still have a mystery. We don't know whose account it was. Not that I think it really precludes with a husband and a wife on a same computer. Maybe not particularly uncommon to have just a single account for something like DNR. I would have liked to have heard more about like what auto-populated when you go to get a driver's license. Is the credit card saved? Lots of times when I go in to buy something off of a website that I've bought something off before, my credit card is saved in it. In that case, it would not be particularly notable that, my credit card is in there, even if it's a website my husband is visiting to buy something. He said that Mr. Allen allowed him to look at the phone to get the ID number for the phone, that MEID number. But he did not ask, he didn't specifically go into, like, scroll through Mr. Allen's phone to look at stuff. He says he doesn't believe he asked Mr. Allen to go into the phone. So I just put a little note. I thought this was very fair. Like, by and large, I thought this witness was pretty fair. He didn't do too much to draw out these, I thought these things were suspicious, which is a very common and extremely aggravating from a defense attorney's standpoint. Thing that law enforcement officer witnesses are often prone to do. They tend to testify in characterizations and opinions more than the just straight facts of what they observed, what they saw, things like that. So anyway, I just made a note of this, that I thought that was very fair of him to volunteer. He doesn't, in fairness to Mr. Allen, he doesn't think he asked him to go in and look through his phones. It wasn't that Mr. Allen said, no, you can't. He recalled that they were both looking for the IMEI and they couldn't find it. So they were talking about the settings. He didn't remember whether they got the MEID number that they ultimately found from the back of the phone or from the settings. But Mr. Allen is the one who, as they put it, manipulated the phone. This is law enforcement tech speak. They just mean he's the one that used the phone and touched the screen and did the buttons and so forth. But to lay people, saying somebody manipulated a phone, it's just not got a very good ring to it. So Mr. Rosie did a recross, and that he addressed that. That's not what you mean. You're not suggesting that he changed anything in the phone or whatever. No. Mr. Rosie revisited this issue with the changes to the height and weight. So apparently what happens is that when you get a new license, it just shows the information from your previous license. So he had the information, this column that he was describing, that shows the change had been made and what had been changed, but it was just the most recent thing that changed. It didn't show like a history of all of the changes that may have been made in the height and weight reporting. So there's basically no way to track what got put in, when, or by whom. He did not hear anything else about the case until 2022, and he says he never thought that that the killer might be Richard Allen. So despite that, sort of in the earlier part of his testimony where he's talking about, the things that are notable that caught my attention, the date of the weight change, height and weight change, that caught my attention. The fact that he wanted to meet at the grocery store, that was a little weird. This is all hindsight. That's become clear. It's hindsight. He acknowledges at the time, never crossed his mind, this guy is our killer. Got some jury questions. The first time you interviewed Richard Allen, what was his hair like? He did not recall. He was asked, the package that he provided contained the lead sheet, the DMV info, etc. Was this a new lead sheet that you printed out if the old one had been thrown away? And so he described his process. He would run the lead sheet through his copier with his summary and the other documentation. And so it would only copy the front page. He would make a copy for himself so that he maintained it in his binder, had a record of it, submit the original to his original packet to a command center, and then he would just get rid of the original document, the original lead sheet. Not clear to me why he would do that. I don't know. Why wouldn't you It seems to me you would take your original lead sheet and the things that you printed out and your printed out summary, you would staple those things together and give them back to the command center. Maybe, whether you make a copy for yourself or not, like, it would make sense why his own copy wouldn't have his notes on the back. But why would you copy the lead sheet separately to give back to law enforcement, to get back to the command center, and then just get rid of the original lead sheet? That seemed weird to me. It didn't make sense to me why a person would do that. It's not efficient. You just take your original, build your packet, copy your packet for yourself, send the original packet over to command center. There's just no reason why you would need to get rid of that original lead sheet. Nevertheless, they did, so the notes are gone. We had our recess after this witness, and then we once again had a new rule. We have new rules pretty much on the daily in the course of our attendance at this courtroom. This one was particularly annoying because it wasn't announced until about 5 minutes into the break, after a whole bunch of people had already left the room. I had not left the room. I was just standing there talking to some people who were seated in my general area. But a number of people had already left the room, and the bailiff came in and announced that now we are being required to all vacate the courtroom with all of our things during each of the morning and afternoon recesses as well, because they are going to continue to reform the line then. And so people can show up in the morning. So there's no consistency or predictability at all throughout the day about whether you're going to be able to continue to stay there. And the problem then is it's creating this situation where every time there's a recess, you have to make a mad rush for the door to immediately get yourself back in line, or you risk losing your spot. So it's just completely disorganized and chaotic. It doesn't make any sense. It's making things worse and not better. And this is just sort of continuing to substantiate, I feel, this perspective that this is being done deliberately. They don't want it to be efficient and economical and fair and sensible. They want it to be chaotic. They want us to all be at each other's throats. They want us to be going Lord of the Rings to be able to get into the courtroom. And I'm very pleased to report, from my perspective so far, there's no hint of that at all. People have been very cool. Nobody has really, been a huge jerk. There's been a couple. I talked about the drama before, but these are very, very minor things. People have been very cool about, like, okay, you're in your spot at line during the lunch break. We're going to have to sit there for an hour. No, if you go and use the restroom, we're not going to say you lost your place. We've been very good about things like they'll move us up and down from different floors. And so, you're in line on one floor. They make everybody go down the stairs to the next floor. It doesn't become a whole like reshuffling of the line. People have been very cool about, we just maintain our position and stuff. So it's really, I'm glad to see, like, from my perspective, it's very heartening to see people are kind of pulling together to make it fair for everybody. Even though the incentives that the court is trying to put on us is to try to divide us, to try to make it a much more antagonistic situation. My view is that we are resisting that so far, and it makes me happy. It makes me proud. It shows that we are not the bad guys in this situation, notwithstanding the court's effort to paint us as such. Our next witness after the break was Steve Mullen. He's testified before. He's one of these witnesses. There's going to be a few of them that testify piecemeal. So they come on to talk about one thing, then they go off the stand, then they'll come back on. This is primarily these law enforcement guys, because they're already sitting there in the courtroom. So they they can just sort of get up whenever, and it's not like they have to leave and then, you know, get called back in or whatever. So he is the investigator for the Carroll County Prosecuting Attorney's Office. He received a phone call from not yet at that time Sheriff Liggett on September 21st, 2022, informed him that they'd located this paperwork, this report about Richard Allen. So Mr. Mullen reached out to speak to Officer Dulan to ask if he had any additional information, and all of that got forwarded over to Mr. Mullen. So then he went in to investigate, to look into whether anybody had followed up with Mr. Allen, and determined that nobody had. He also ran Mr. Allen through the DMV database, found that he had 2 vehicles registered to him. He had a 2006 Ford 500 and a 2016 Ford Focus. Mr. Mullen then went to the Hoover Harvest store to see if he could locate either of those vehicles on their surveillance video. He also learned that Mr. Allen worked at CVS, and so he went there, found his vehicle in the parking lot, and took a photograph of it. So then that is what he used to compare to the Hoosier Harvest store video. He said he looked from noon until about 1 o'clock and beyond on the video, looking for a vehicle matching the description, and he found one that entered the frame at 1:27 p.m. on February the 13th. Mr. Baldwin challenged, he spoke up at this point. He objected to the characterization of the vehicle as being a match. He was saying it's just his opinion based on how it appears, the features, the size. He believes it's the same car. And so Mr. Baldwin is objecting to calling it a match when he's saying it's just his opinion. Mr. McLeland is trying to say, you know, he can testify to his opinion. They sorted out by basically the judge says, well, he can call it the vehicle. So this objection is sustained. He's not supposed to say a match. So they start reviewing the exhibits that are introduced, which is basically photographs of the different frames in the video that show the vehicle passing, and asking him to identify these exhibits. And he says, these are a frame by frame of when Mr. Allen's vehicle passes by. Right after this objection to calling it, you know, a match has been sustained. I have a little note in my comments here. This guy is a real, I'm not going to say what I put in my notes. Real piece of work. Real piece of work. Sneaking that in, trying to sneak that in. So Mr. Baldwin again objected, and the judge, you know, says you need to call it the vehicle. So he rephrases, it's a frame by frame of the vehicle passing by. The direction is that the vehicle enters from the east on that 300 North County Road. It travels westward. One of the vehicles is a close-up, a zoomed-in version of that video frame. So we were not able to see these. Once again, all of these were published to the jury as paper copies, despite having that nice overhead projector thing there in the prosecution's table. They didn't use it, so they didn't display it to the courtroom, and we were not able to see any of what that was. I also made a little note here that while they were going through these photographs, while the jury is thumbing through their own copies, Judge Gold was doing this thing that she does. She has a couple of modes in trial that I've noticed. One is where she seems to be doing things on her computer. And the other is that she tilts her head way back and glares down her nose at the audience. She's got a very pursed mouth expression, so it's... looking down her nose, glaring at us all in the courtroom. She's doing this while the jury is thumbing through their pictures of the car that we, of course, are not able to see. So we can't tell. Does this car that that you found on the video, does it look like Mr. Allen's car that you photographed over there in the CVS parking lot? He noted that you cannot see the license plate of the car. You cannot see the driver of the car. All the video shows you is the car. So he was asked what were the distinctive characteristics of this car that led you to think it was Mr. Allen's. And he said it was the general shape and appearance. It was a hatchback car, commonalities in the taillights, the bumper, and then in the rims and the wheels. He said the picture at the CVS lot shows that there's a black sports rim that has spokes, so you can see daylight through the spokes, and that you could see the light through the wheels of the car in the video. The time of 1:27, he said, was significant because Mr. Allen said he arrived at the CPS building at about 1:30, so these things correspond. If that was Mr. Allen's car, that would correspond that he arrived at the CPS building coming from that direction at about 1:30. He ID'd the white building that they were talking about, the CPS building, on the map. So now I know when they go to the map what they're talking about. It's kind of hard to describe where everything is without having the map on here. But basically, it's just the road 300 North connects to Main Street, and it's a little bit further up. Like you pass. It's sort of hard to describe. We have this very long building on the map. If you see an aerial map of this area, this very long building on 300 North, that is the Hoosier Harvest Store. And so it's basically diagonal about 11 o'clock at an angle from Hoosier Harvest Store back in the area closer towards Main Street. Mullen followed up on after they got this car image, and because they wanted to talk to him, so they drove out to his house on Whiteman Drive on October 13th of 2022. They spoke to him there at the residence. This was Mr. Mullen and Liggett. They said they wanted to ask him questions, that he was not under arrest, that he could leave at any time, and so with his consent, they put him in the car and took him down to the station. He was not handcuffed, and he wasn't in a patrol car. He was just in a unmarked Mr. Mullen drives a unmarked 2014 Buick. So that's what he was in. They put him in an interview room. They advised him of his Miranda rights, and they began to question him. So during this interview, remember now 5 years after the date in question, Mr. Allen said that he had gone to his mom's house north of Peru. He was off work that day, and his wife Kathy was working. He left his mom's house at about 11:15 or so. He went home to pick up a jacket, and then he went to the trails. He said he walked past 3 girls and didn't see anyone else because he was looking at the stock ticker on his phone. He parked at the old building. He said that he arrived at 12 and left at about 1:30, that he started at the trail entrance, walked to the high bridge at the end, and he went out as far as the first platform to look at fish. He ran into the girls somewhere at the beginning of the trail. They were walking away, which he interpreted to mean they were walking away from the Monon High Bridge. He described, asked what he was driving. He said it was the 2016 black Ford Focus, the same car that he had registered in 2022. Asked what route he took to the trailhead. He said he wasn't sure. He may have gone through the country. Sometimes he goes through the city. They asked to identify on the map where Richard Allen's house is relative to the trails. His house doesn't show on the trails, but they said it was basically south of that location. And so, according to Mullen, he identified two possible routes to get to the trails from Mr. Allen's house. One would come up on East Main that goes in the direction towards downtown, and so that's the city way. The country way, he would go east from his house on 200 North, which is another county road that runs parallel to 300 North. So he would go right on 200, left to go north to connect with 300, left on 300 and go westbound towards town. And that way he would have passed the Hoosier Harvest Store. So that does sound like it's not the direct route. He has to kind of take a C route to get to that one, whereas to get to it from the Main Street route is much more direct. Said he spent about an hour out on the trails, and that what precipitated him making this report is that he had told his wife he had been out there, when the girls went missing. So that's what led him to contact the police. He acknowledged that he was wearing a blue or black Carhartt jacket, some blue jeans, what he described as a skull cap, and some military-style boots. He described one girl as appearing older and the other two girls younger. Said he first agreed to let them look in his phone, but then he changed his mind, and at one point he became agitated and walked out of the room, and that is how the interview was terminated. He did not recall exactly what he had told Officer Dulan about his time on the trails. He said he didn't think he was out there as late as 3:30. They asked him if he was Bridge Guy. They showed him the picture of Bridge Guy and asked them, "Was this you?" And Officer Mullen characterized his response as strange, weird, unique, notable, stood out. He said, if the picture was taken with the girl's camera, there is no way it was him. Does that seem weird? If he knows he didn't see the girls, doesn't seem that weird to me. They took that information and they processed everything they had, got a search warrant, went and searched his house. He confirmed that Mr. Allen did own this black Ford Focus back in 2017. They had seen the car in the garage when they went out to his house the first time to ask him to come to the interview. And at that time, he said he had purchased it new in 2016. We broke for lunch at this point. A couple of things happened. First, it was notable because this was very shortly after the first break, and it was at about 12:10. Our first break we took at right around the ballpark of 11 o'clock. So we didn't go a whole lot longer before we then took the long break for the day. This sort of stood out because Judge Gull has specifically said and has told the juries they're trying not to split up the testimony of the witnesses. They're trying to get through a witness and then go forward. And so in situations before where we've been in this situation, it's approaching the lunchtime, but the witness is still on the stand, we just continue to go and we take a little bit of a later lunch. We've taken our lunch as late as like 1 o'clock. So I found it strange that on this particular occasion, they decided to stop. And it seemed like this was kind of the high point. This was kind of the high point of the day for the state. This direct examination of Officer Mullen. He had made this connection between the car and then the car with the timeline, when exactly Mr. Allen had been out there at the trail, these changes, and he was able to characterize all these things as strange and suspicious, the way he answered the question and stuff like that. So this in my view was really about as close as they got today to like, yeah, Mr. Allen, maybe they're onto something. Maybe these are a lot of coincidences, and that would just be too much to think that it was all just circumstantial. The other thing that happened is that because, of course, we, have to do our rush to, to get out of the courtroom and get back in line, people start, as soon as the jury is out of the room, people start, gathering their things and getting ready to go. There's literally like a sprint to the door. It's a big bottleneck because, you don't want to lose your position. You want to be able to get down there in line because if somebody is in front, then some of the people who have been in the courtroom before aren't going to be able to get back in, so you don't want to be that person. So because of that, it makes a little bit of noise, a little bit of disruption. The judge snapped at us. Folks, we're still working here. Please be quiet. Like, straight up. Never going to see it in the transcript. Never going to see it in the transcript. Boy, did we get snapped at. I think the jury was actually not even out of the room yet at this point, now that I think about it, because I remember thinking, I wonder what the jury is going to make of that. I wonder, like, do they like that? Do they see that and think, yeah, this is a great judge who is, she reminds me of like a stern parent who's really keeping these unruly people in line? Or are they like me going kind of, what the hell? What is the matter with this woman? New situation for lunch too. This has changed on a pretty much consistent basis because what happens is we leave the courtroom, we reassemble our line, but we aren't allowed to stay on the third floor because they transport Mr. Allen out, and we can't be on the floor when they transport Mr. Allen out. So the first day we were sent back down to the second floor. The next day we were told, oh, you can just stay on the top steps. Then we were sent back to the second floor. We've been at the second floor for a while. Well, today we got sent all the way back down to the first floor. And so we're down there in the main area where anybody coming into the courtroom for their own business, we're right in their way. We're taking up the foyer. We're blocking one of the exits. There's nothing we can do about it. We just are where we're told to be. But yet again, here we are just making it worse for everybody for no reason that I can really ascertain. I don't know why we needed to be down on the front floor, down on the bottom floor, in everybody's way, as opposed to hanging out on the second floor where we have been perfectly fine for several days already. Mr. Baldwin really came in hot when we came back after lunch and got into the cross-examination. He came in hot. It became crystal clear, my little note that I made about Mr. Mullen. Yeah, Mr. Baldwin shares that opinion. It became very clear. He opened as follows. You are so desperate for this car to be Mr. Allen's car that right before lunch you lied to this jury. Well, that naturally drew an objection. It was sustained. I didn't think this question was particularly out of line. It's a very tough question, but it's going straight to his bias. Bias is one of these areas that defense has a lot of leeway to be able to inquire into. It's just one of the fundamental parts of why you have cross-examination in the first place that the courts have recognized. If you can't get into why a witness might not tell the truth on the stand, then you can't effectively challenge what they're saying. So you get a lot of leeway to cross-examine people for bias. I could see maybe if I'm being nitpicky with the you're so desperate for the car to be his, but he's asserting a proposition, No problem from my view with saying you lied to the jury, making him answer that. You lied to the jury. But they clearly did not like this. They didn't like it. He says that Rick told you, according to your testimony, Rick told you he possibly drove the country road westbound on 300 North in the interview. He possibly took the route that he described, the C-shaped route that would put him in front of the Hoosier Harvest store. According to his testimony, Rick said he possibly took that route. Mr. Baldwin says the videotape interview of his October 18th, the October 18th interview, it's videotaped, and everybody can see it for themselves and exactly what he said. And Mr. Mullen starts to get quiet at this point. Yeah. So the glorious part of cross-examination, impeachment. Mr. Baldwin hands in the transcript of the interview, and says, where did he say that? We then sat for 6.5 minutes while Mr. Mullen thumbed through, I don't know if he's Mr. or Officer Mullen, thumbs through this deposit, thumbs all the way through this interview transcript, gets to the end, starts thumbing all the way back through it the opposite direction. He starts mumbling to himself. He's looking for the part where he said he went by the Mears entrance, but it's not an answer. Mr. Baldwin's like, you know, are you answering the question? That's not what I asked. He's like, no, I'm just talking to myself, which is also improper. You're there to answer questions as a witness. You're not there to have a soliloquy. The judge is doing this while he's thumbing through the transcript. The jurors are watching this intently. So he finally identifies, he says on page 45 that Mr. Allen had said he had gone past the Mears entrance and there were a couple vehicles there, and that he was referring to possibly having gone in that direction, and that was his interpretation. So Mr. Baldwin says, no, he told you he went his normal route through town that went eastbound on 300 North. Mr. McLeland objects. He objects to the form of the question, that this question is asserting facts that are not, it's not facts not in evidence. I think he's trying to say that he's stating facts that are not reflected in the transcript. So this objection is sustained. Officer Mullen, he concedes when he sees the video, the Hoosier Harvest Store video, and the car on the video, he had already decided, he had already surmised that that was Mr. Allen's vehicle. So then Mr. Baldwin asks, when he didn't tell you he went the way you wanted him to go, he gets cut off at this point again. Objection. Form of the question. That objection is sustained. I don't think there's anything wrong with this. I don't think there's anything wrong with this. You're getting into his bias. Mr. Mullins is still flipping through the transcript. They find where he asks, which way do you think you would have traveled? And Mr. Allen says, loop through town. And that would involve taking 300 North eastbound. Mullen says, I remember he said he had possibly gone the other way. He said it was one possible route that he took. So Mr. Baldwin then directs him to a very specific point in the transcript. He says, you interviewed Richard Allen on October 13th, and he said the loop that takes him to 300 North eastbound. There's now an objection again to the form, facts that are not substantiated by the question. That's sustained. And he said he asked him a little bit later, is there any other way that you drove? And that's because on the video of the interview, so where it would not be reflected in the transcript, he demonstrated on the map. He pointed out the route on the map, showing that he went 300 north eastbound. So this is where he's getting the fact. Mr. McLeland is objecting, saying that he took the loop that would put him on 300 north eastbound. He's trying to keep that 300 north eastbound out. He's saying that's not in evidence. So you can't ask that question. The form is improper. These objections are getting sustained. Mr. Baldwin points out he showed you that it went eastbound on 300 north when he made that indication on the map. And he asks, so when he said he didn't go westbound, you asked if he went any other way. Specifically, so they're objecting now. Now Mr. McLeland is objecting because he says Mr. Baldwin is not stating the question accurately from the transcript. He's paraphrasing it. So Mr. Baldwin goes ahead and reads the question. Was it ever an occasion when you went to the park another way? And then brings out that he asked him a second time if he went west. And Mr. Baldwin says he told you if he was going to the Monon High Bridge Trail, he would go through town. Mr. Mullen says, that's not how I interpret what he was saying. Mr. Baldwin says, well, you cut him off, didn't you? He said, I'd drive through town. Now there's a new objection. The new objection now is that Mr. McLeland objects to him reading from the transcript. Just moments before, Mr. McLeland had objected to him not reading from the transcript, and that was sustained. Now he objects to him reading from the transcript, and that's also sustained. This was so obvious, the obstruction of him being able to ask his questions. I have to believe the jury noticed this, that he is having it both ways. You can't ask the question if you don't read the transcript, and you can't ask the question if you do read the transcript. Those are the rules that the court is upholding in this trial. I have to think that at least by now the jury has noticed that. Mr. Baldwin asks him, words matter. Yes, yes, words matter, particularly when they affect the timeline in a case like this. And so Mr. Mullen now kind of backpedals. Well, it's my interpretation was that he took the scenic route when he traveled that way. Mr. Baldwin says he told you he would have been driving his car that day. Officer Mullen says he changed his mind about that later, but that was, again, his interpretation. It said it was weird. He again reiterates it was weird how he said if there was a picture taken on the girl's phone, it wasn't me. Mr. Baldwin pins him down that for his theory to work, his car, Mr. Allen's car, has to be at that CPS lot between 1:30 and 4 o'clock p.m. for his theory to work. He concedes, yes, Mr. Allen's car has to be in the lot between 1:30 and 4 for the state's theory to work. They have pinned them down on the timeline of the car. Mr. Baldwin asked, did anything in your investigation contradict that? Mr. Mullen says, not that I'm aware. And Mr. Baldwin says, have you heard of Betsy Blair? Officer Mullen, he's very quiet by now. He said, yes. Yes, he's heard of Betsy Blair. Mr. Baldwin holds up the picture of the car on the video. Does this look like a 1965 Mercury Comet to you? So McClelland objects to this, and he asks to approach. You remember when Betsy Blair was testifying, the state didn't ask her about any of that. When the defense has her on cross-examination, Mr. Baldwin starts to ask her about the 1965 Mercury Comet. Mr. McClelland objects at that point that it's beyond the scope of the direct, and that is sustained. So we had that conversation about how if you want to be efficient with the trial, this is one of those technical rules that makes absolutely no sense at all. You just let the defense go ahead and do their own direct while you already have this witness on the stand, and you don't have to go through the whole pain of letting them go, you know, and bringing them back in under subpoena another time, whether or not it's convenient to them, because they have to be there. When you're, you know, courteous to your witnesses, you just get it done. So Mr. McClelland had objected, that got sustained, so they didn't get to go into that line of questioning from Betsy Blair. So of course we don't know what happens at sidebar. This was an objection that took place at sidebar. But it was very clear that that's what he was getting at. This is not in evidence because Betsy Blair hasn't testified yet, so you don't get to impeach him with something that Betsy Blair hasn't said yet, even though he has opened the door, you know, by denying that he had any information that contradicted Richard Allen's car being in the parking lot from 1:30 to 4 o'clock, and he knew what Betsy Blair had previously told him. They should have been able to bring this in. This was ridiculous. But he does move on. He asks, were you in charge of the evidence logged in 2017? Now we're going to try to pin down who is it who's making all these mistakes. Heard a lot about who didn't make the mistakes. So who's in charge? Was it you? Objected to that one is beyond the scope. That was also sustained. So at this point, Mr. Baldwin made it through, I mean, a good dozen objections, at least a dozen. All of them, I think with the exception of one, one was overruled, everything else was sustained. So he was extremely obstructed in his examination. And I have to think this is starting to become evident to the jury. The jury expects people to be forthcoming. They expect that this is a process where we all want you to know what we know. We'll give you all the information and you can decide based on that. They are not impressed by like the gamesmanship and hiding things and stuff like that. Juries tend to feel manipulated by those types of things. They tend to dislike it because it feels like it puts them in an unfair position where they have to make this decision based on what they know is incomplete information, and they resent that there's stuff out there that's being kept from them. It became crystal clear in the course of this examination. The state is trying really hard to keep stuff from you. I really have to think they noticed that. Mr. McClelland's redirect was simply when you were describing what Mr. Allen said during your direct examination, you weren't giving me direct quotes, were you? And he said, no, not necessarily. Yeah, we know that because you got your ass impeached with what Mr. Allen actually said, which is not really how you characterized it. It really isn't how you characterized it. We had 3 jury questions for this one. First question. Were you in an interview with Mr. Allen when he stated he didn't know what way he took to the trail? The answer to that was yes. This seemed like a question that is favorable to the defense, but not nearly as much as the next question. Did you investigate how many 2016 black Ford Focuses are registered to Carroll County residents? Isn't that a good question? Isn't that a good question? No. No. He saw it. He knew that Mr. Allen had one. Decided that's his car. Didn't matter how many others there were in this area that it could have been. Didn't bother to look. Frankly, probably didn't even cross his mind, because he had already surmised it was Mr. Allen's video, or Mr. Allen's vehicle. The jury asked, did you look to see if his other car was on the Hoosier Harvest Store video? Yes. The follow-up from Mr. McLeland, did you see it there? No. And did you see any other cars that looked like Mr. Allen's black Ford Focus? No. I felt like this was not a good moment. This was not a good moment for the state. This was a throwdown, and it came across as Mr. Baldwin was coming on strong. He was letting his hands go. And Mr. McLeland is hanging back and rabbit punching him. Cheap shotting. Not letting him work, but just doing the gamesmanship. Not a good moment for the state. This little time with Officer Mullen. Our next witness is now Carroll County Sheriff Tony Liggett. So Tony Liggett, he was a detective back in 2017. He was also the chief deputy for Carroll County. He was part of the Abby and Libby investigation. So in September 2022, Kathy Shank brought him the tip lead to review, and the summary of from Dan Dulan. He said it really stuck out because he wasn't aware anyone had seen Riley Voorhees and Bree Wilbur, because we believed that that was Bridge Guy. So that was important. He knew that Riley and Bree were out on the trails. They had passed the guy coming in as they were leaving. We spent a lot of time reviewing what has already been established. It sometimes gives me an impression when people do this that like you have to repeat all the stuff the jury already knows. You're trying to get them to confuse volume for quality. That just if you have a lot of stuff, if there's a lot of words coming from these witnesses, you know, that it makes it sound like there's more than there is. But what he wanted to do, I think it became clear, is he wanted him to summarize essentially the investigation to date, what led them to Richard Allen to suspect him, so that they could just kind of have that all laid out in one spot. And the jury could hear, you know, here's like the sum total of what led to us being suspicious of Mr. Allen. So started with, you know, the interaction with Rayleigh and Bree, which of course is not what Mr. Allen said. But the interaction with them out on the trails, the fact they had passed the guy, he puts himself there. He had seen, of course, the photographs of the car and the Hoosier Harvest Store video. The timestamp is 1:20 or He had seen the photographs that Riley and Bree had been taking out there on the trail, the photo that they described at the bench. Saw the timestamp that it was 1:26, that it was shortly after that when they passed the guy. The bench was close to Freedom Bridge. He did indicate on the map where they had taken the picture, and he pointed to an area that was like way far beyond the farmhouse. That's what the witnesses used to identify where the bench was, because they said it has its green roof in the background, and so we were able to tell where it was because a green roof is on this farmhouse. Sheriff Liggett points like way, way, way closer to the beginning part of the trail as the part where they took the photos. He was familiar with Betsy Blair's interview and with her Fitbit info, that she was on video arriving at 1:46 and leaving at 2:14. And so she had seen the man on the first platform in the early part of that time frame. Then Sarah Carbaugh at 3:56 saw the man. She's on video going east, and just past that, she saw the man walking west on the north side of the road. They found this .40 caliber Winchester bullet. Libby's cell phone was found under Abby. They found the video of the man in blue jacket and jeans walking behind Bridge Guy. So we paused here because he started talking about enhanced formats of that video and how one of them stabilizes the video so that it keeps everything upright instead of like we've described it, the video, it's extremely jerky. It moves around. You can't see anything very well. And it's just, you get very brief glimpses of like Abby, you know, when it's upright and stuff. Most of the time, the phone is pointed at the ground. And he says at one point, this enhanced video pauses and it zooms in on Bridge Guy. So we get to watch this video. This is played in the courtroom. There's no objection to it, so I assume that because I had questions about how did you do this enhancement, especially after we saw it. It looks so different from the original source video, particularly with respect to what you can see of Abby on the bridge. But he also made a point that I thought was very interesting, because I wonder if it's gonna stick with the jury when they get their final instructions in the case, if they get them. Let me just clarify. He said that he has viewed that enhanced video hundreds of times on different devices. It's best with headphones on so that you can block out the ambient noise. And so based on that, he's formed an opinion about what is said on the video by sitting and listening to it hundreds and hundreds of times. Here's why I think that's important. When we were at the pretrial motions and they were talking about what the process was going to be for submitting and presenting these digital exhibits, one of the points the judge had made is that if they ask to view it, they're going to be brought into the courtroom and it will be played for them one time. They're not going to be able to sit in there and watch it over and over and over again. So they're not going to be able to do what Sheriff Liggett had to do to figure out, you know, in his opinion, what was said on this video. They're not going to be given this opportunity. And I wonder if they're going to realize that, and if they do, how that's going to sit with them, because it kind of comes across as you're going to take what he says they said and like it. That's your choice. So in his opinion, when the video starts, Abby says, "Is he right here? Don't leave me up here." Libby starts saying, "See, this is the path." Whispers, "That be a gun." Then she says, her tone changes and she says, "There's no path here. We have to go down here." The man says, "Guys." They say, "Hi." He hears a gun rack. This is objected to by Mr. Rosie as mischaracterizing. So he's turning Mr. McLeland's objection back on him. This is sustained. I was rather surprised. It was sustained, and that particular comment about hearing the gun rack was stricken. So, jury is not to consider it. Of course, the bell has now been rung. And then down the hill. So, guys, high, some sound, down the hill. So that was all the info that they had in September 22nd, plus the new info that they got from Shank when he called Mullen and told him about it. They researched Richard Allen, found his vehicles, found that he worked at CVS, got the picture of his vehicle at CVS, made a note that his vehicle was backed in. They thought this was notable because the people who had seen the vehicle at the old CPS building said that it was backed in an area where people don't normally park. Surely two different people could not park their cars by backing in. This is a real smoking gun here, isn't it? Pardon my sarcasm. I was reading something not that long ago. I forget where it even came up, but it was saying that it was talking particularly, they use the term high trust societies. They're talking specifically about Asia, like Japan and China. But they said in high trust societies, it's far more common for people to park by backing in than it is by pulling in nose forward. And it's generally because it's easier to see. It's like safer to get out. It's easier to see. And so there's less risk that, you're doing that. I'm going to back out in front of somebody and whatever, which is a little bit discourteous. So it's more difficult. It takes more upfront time to do the backing in, but it's much easier to just pull, blaze in nose first into your parking space. But when it comes to getting out, it's much easier to get out and much safer and more courteous to others. So societies that are maybe less individualistic than our American society are much more prone to park backed in. I share that for whatever it's worth. I don't even know if it's true, but I found it very interesting and it resonated with me. I like to back my car in. I don't do it all the time, but yeah, it's much easier to get out when you do that. So yes, smoking gun, the vehicle's backed in, just like that car at the CPS lot. They found out that he had a lifetime firearm permit. Again, compared the store, the video from the hardware store to the photos of his car and found a matching vehicle. Thought that it was the same based on the general outline and the daylight through the wheels. So they contacted Richard Allen and interviewed him. He admitted he was on the trails, changed his time, told Dulan 1:30 to 3:30, and then changed it to 12 to 1:30. Said he went home and got his blue-black Carhartt jacket. Just basically reiterated this same, contents of the interview. Some things that he added that Officer Mullen did not mention was that he said normally when he went out of town, he would drive the 2016, I think was not his car. It was primarily his wife's car. But he said when he went out of town, he would primarily drive the 2016 car because the older car wasn't as reliable. And so he had gone to see his mom near Peru that day. So it was possible that was the car he had taken. I don't think he knew which car he took, but he just said, he'd gone out of town. So it's possible that that was the car that he took. So he'd been out on the first platform to look at the fish. That was what he said in the interview. They described when they were at his house, when they arrived to his house, they were in his garage. And they knew that he had firearms because he told a recent story about someone being in his yard. And so he took his gun out with him to, as Liggett put it, to confront them or to see what he was doing, and discovered that it was a police officer. So this was the story. Just trying to make him look bad, like every way they can. You can't just be like he took his, he told you he took his gun out, when there was a strange person in his yard, like people might do, if somebody's lurking in my yard, might have my gun with me if somebody's if I'm gonna go say something to him. But gotta make him look bad every opportunity they can. They got the warrant for his home. They searched his home. So he gives us the details of what they recovered from the home. They recovered a Sig Sauer handgun. They recovered a .40 caliber bullet, the same caliber of bullet that was found between the bodies of Abby and Libby. They found this .40 caliber in a keepsake box that was on the dresser. That it was .40 caliber Winchester, which was the same brand as what was found on the scene. They found other ammunition as well, but that was all .40 caliber Blazer ammo. So the only Winchester was the one that was found in this keepsake box. They found a blue Carhartt jacket in the main entry closet. They sent all of this stuff to the lab because they knew the lab could compare the bullet to Richard Allen's gun. They found the gun in the nightstand by his bed. They found clothing on the floor on that side of the bed that belonged to Mr. Allen. He described it as CVS clothing. They did an ATF trace on the gun to get the owner information. It came back to Richard Allen, and he was the only owner of that gun. We don't know when he got the gun. He didn't say. But it didn't come out on cross, so I will assume that he had the gun in 2017. Mr. Rosie, he was the champ today. Oh, he was a champ. He worked this sheriff over. He beat him up. He bloodied him pretty good. In October of 2022, he concedes he was the chief deputy. That means he was the number 2 in charge, and he was in an active election. He had survived his primary in May. He was working on the case as part of the unified command at the time that he decided to run for sheriff. He was going to make about $50,000 more if he was elected. Mr. Rosie asked him, "Did you ever once think about the impact that making an arrest would have to improve your chances of winning the election?" Mr. McLeland objects to this. He is outraged. Is counsel suggesting that he would make an arrest to help an election? It's cross-examination for bias. Yeah, you get to ask that. Are you suggesting? No, it's we're asking. Did it ever cross your mind? Such a legitimate question. Absolutely legitimate. Ever once crossed your mind, might help me out getting elected if I'm able to arrest the murderer of these young girls for this crime that has traumatized our community. Mr. Sheriff Liggett, it was only ever about 2 little girls that had been brutally murdered. So Mr. Rosie asks it again. Ever once just cross your mind? Now the objection is it's been asked and answered. Mr. Rosie, rightfully, in my opinion, points out he didn't answer the question. He didn't answer it. He answered some other question that he wished I had asked, but he didn't answer the question I actually did. Because the answer that I actually did is a yes or no question. Did it ever once cross your mind? Judge says, yeah, he did. It's sustained. Well, I have to infer from that then that his answer is no. No, it never a single time crossed his mind that that would be such a heroic thing for him to do for this community. He acknowledged the search parties were sent out at about 5 p.m. or so with the law enforcement on the evening of February 13th. It had expanded. There were dozens of people out. The fire department came. They were dispatched to all areas around the bridge. He did not agree that they had sent emergency vehicles down to Weber Lane. We had heard from the law enforcement officers earlier. I'm not going to remember offhand exactly which one, but they had testified that they had in fact been down there and had their lights shined on the creek, lighting up the opposite side of the creek. So he didn't agree with that, but nevertheless, the jury has already heard that that happened. They were out until midnight. Mr. Rosie asked if he knew a Carl Abbott, that he lived out on 300 North past the cemetery, and if he was aware that the search on the 13th extended as far as behind his house. Mr. Sheriff Liggett says he's not clear if the people searched the field behind the house. Sheriff Liggett also did not agree that there were breaches of crime scene integrity at the time in the early days of the investigation. He said nothing came to mind about photos being released in 2017, photos leaking. This has been a subject that has come up a few times, so I am expecting that the defense is going to be able to substantiate this when they get to their case in chief. They're going to have somebody or some, proof that there was an early leak of crime scene photos. They have to have a basis to ask this question. You don't get to just fish with random things. So I would think so, but that will remain to be seen. He did acknowledge that there was some information that got out about the crime scene, about the crimes. He said he never gagged his police officers, and he said it wouldn't have been my place. And Mr. Rosie was like, "You were the only detective in this department." He's the chief deputy. He's like the guy running the investigation. Gotta wonder whose place it would have been to tell the police, maybe you shouldn't leak details about this crime scene because that's sensitive information and that could affect the integrity of our investigation. Nope, he says it wasn't his place. They talked about the sticks, and Sheriff Liggett is of the opinion that they were used for concealment. Mr. Rosie asked him, wouldn't you agree it was pretty poor concealment? And Sheriff Liggett says, but nobody saw them. It was the sticks that concealed them. Now, not the cover of darkness and the remote location. It was those sticks. Mr. Rosie is kind of like taken aback. He's like, the sticks weren't covering them. And Sheriff Liggett reiterates, but nobody saw them. He is aware of what Ms. Blair and Ms. Carbaugh and Ms. Wilbur and Ms. Voorhees said. And based on that, he decided to get a search warrant for Richard Allen's house. He confirmed that the search warrant is an affidavit where you swear certain facts to the judge that the judge relies on in order to decide if you should have permission to enter somebody's home and take their things without their permission. And that part of the search warrant was focused on the timeline that had previously been discussed, that the search warrant affidavit articulated facts about what each witness saw. Sheriff Liggett confirmed he has reviewed the affidavit as recently as within this last week. And he discussed Bree Wilbur in the affidavit. And Mr. Rosie asks, you never offered the court information about the man being tall and muscular, as Bree Wilbur described him. And he says, I don't remember. Mr. McLeland objects to this as well. This objection is strike that back. He asks if he saw a report that Bree describes the man as muscular, or if he remembers a report that Bree described the man as muscular. It was objected to, and that objection is sustained. Don't get into the shenanigans with the search warrant affidavit. They had a sidebar during this, and my suspicion is that Mr. McLeland argued this went to the Frank's argument, the argument that you know, things were left out of the affidavit that created a misleading impression. Therefore, it's the kind of thing that's resolved pre-trial. It's not something the jury, you know, that the jury is there to decide. This is just my guess, because I don't really know what the basis would be for not allowing him to be impeached on his credibility when he's selectively cherry picking and excluding information from the search warrant affidavit. This is an issue that is a particular hot button issue for me, the cherry picking of information for the search warrant. We do have this rule, arises from the Delaware versus Franks case, that if you omit material information from the search warrant that results in a misleading impression, that's a violation of the Fourth Amendment. That's basically you're tricking the judge into letting you violate somebody's privacy rights. But it is a rule that has very dull teeth. It's very difficult to meet the standard. You typically don't get suppression for stuff like this for all kinds of reasons. The reason why this is a particular hot button issue for me is because the search warrant affidavit is there to allow the judge to decide if there is probable cause to believe that there will be evidence of the crime in the area that is to be searched. And every description, every case law establishing what probable cause is tells you this is a totality of the circumstances determination. It doesn't have to be a high bar. It doesn't even have to be, even though it's probable cause, it doesn't even have to be a probability. It doesn't have to be like a 51%. It just has to be like, yeah, okay, sounds logical. That's pretty much the bar. But it needs to be sounds logical based on the totality of the circumstances. So when police go and just leave out certain parts of the totality of the circumstances, yes, they are giving the court a misleading impression about whether there is probable cause here. Because you got to wonder if they knew, hey, these people described Bridge Guy as like 5'10" and curly hair and in his 20s, and we want to search the home of this guy that we think is Bridge Guy that's 5'4" and in his 40s and not particularly muscular and has a buzz cut. Think the judge might change his evaluation about that? Does that sound like, oh, that sounds logical? No. So you leave that information out. You just leave that part out. You just tell them the part. They just tell them the part that supports what they want to do. And this is, from my experience, unfortunately, pretty routine. Pretty routine to just leave out the stuff that doesn't support their case. So I find it extremely frustrating. They do it all the time. They always get away with it. You almost never even get a Frank's hearing, let alone a ruling on a Frank's motion. So the fact that now he's not even going to be allowed to impeach one of these officers who did this kind of cherry picking on his credibility when you're willing to mislead a judge like this, do you think you might be willing to mislead a jury like that as well? Pretty important inference for the jury to be thinking about. And he's not allowed to do it. Mr. Rosie points out that the Hoosier Harvest Store video is the camera is facing the 300 North, and that Sarah Carbaugh described a man that was walking westbound on the road. He's leading him down a path here. So first he asked if Sheriff Liggett ever looked for cameras on the backside of the store. No, he did not. Points out that it's a very long building. There's a whole bunch of storage in the back. There's other things going on. Points out if this man was continuing down the road to the CPS lot, he should be on that video, right? Yeah. Yeah, he should. And there is no man walking on 300 North on the Hoover Harvest Store video. Hoosier Harvest Store. This is like a tongue twister. I'm having a bad time with the Idahos and the Bevs, and now Hoosier Harvest Store. I have a hard time with that. I don't think I've called her Bev today. I don't think I've called them Idaho today, but I could be wrong. It's the ISP. I shorthand ISP in my notes, and I've been shorthanding ISP in my notes for Idaho State Police for Brian Koberger for almost 2 years. And so I think it's just in my sleep-deprived state. I look at my notes, I see ISP, you know, my wires cross, and I just default to Idaho because that's where my mind has been for so long. That's my habit, and that's what comes out of my mouth. But I do want to clarify, because people have contacted me to ask, no, there has not been testimony about anybody from the Idaho State Police helping out with this investigation. It's been me misspeaking. It's Indiana State Police. Sorry about that, guys. Trying to pay attention now and not do that anymore. Nobody was walking on that side of the road. So Mr. Rosie goes through, there's a few options. There's really only a few options that there could have been for this guy. He could have gone south and gone back into the woods. That's an option. He could have gone kind of southwest over to the Mears entrance, over to where that connector is to the trail. The problem there is that, you know, there's lots of people out there. His other option, he could have gone north. He could have cut through the Mears property and then over to the CPS lot. This was an active farm at the time. Mr. Rosie asks about the Mears connector. The problem, of course, if you tried to go that way, there's people over there. And frankly, even if you walked in that direction, there's people over there. And he's saying in February, when all the leaves are off the trees and the visibility is about as good as it ever gets, you'd be able to see out to the road from the parking lot. Well, Sheriff Liggett doesn't want to give him that. No, it's a very thick woods. It's a pretty thick woods in there. These are not thick woods. These are not thick woods. I was very impressed when I went down there that these appear to be relatively old stands. You can tell an old forest from a young forest, a forest that's in early succession, like it's been, you know, cut down previously, because of the thickness of the undergrowth. When a forest is mature, the trees are very tall. They shade out the ground beneath them, so you don't have a ton of things that have been able to compete for the light. That the trees are taking most of that up, and that's the condition of most of the woods out there in this area. It's very beautiful. I really, really enjoyed it. They're mixed stands, like all these different species of trees, some very large trees. It's a beautiful, beautiful area. There's a whole big section of it that's part of, I didn't get the full details. They've mentioned briefly that there's a trail that at this Mears connector that takes you down to Deer Creek. I walked that trail. It was part of a property that belonged to a naturalist, a guy who I believe was an educator. And this was like his summer getaway. He would lead nature hikes out here all the time. It's now owned and managed by the local land trust, which is something a little close to my heart, land trusts. Someday I'll talk about that too. So yeah, these are like conserved forests. They're beautiful. They're large trees, open stands, not thick, fresh, new forests where all kinds of things are coming up and competing for the sun. And eventually, you know, some of them will grow faster than others, shade them out. Those ones will die off, and you'll end up with the type of forest that we have out there. Sheriff Liggett says, no, you couldn't see out to the roads. It's a very thick woods. I don't buy that at all. I don't buy that at all. They did not search any area to the west for discarded clothing. They did not search north of the farm. They did not search around the Hoover Harvest Store property. Mr. Rosie is asking him, he's now getting to the opportunity to go through there. He's like, there's a fence line over there behind the Mears property. Sheriff Liggett, well, I don't know that there's a fence. I can see that there's a line here on the map, but I don't know that that's a fence. Rosie's like, okay, same thing with Hoover Harvest Store, same thing. I see the line, but I don't know what that line is. That could be a fence. There is another wooded area that's kind of between the trails that would connect. Like if you're trying to get back to the CPS area that's up in that building, they described it as where the train tracks are moving through. It's an area that belongs to the Anderson family. Nobody searched in that area. So basically what he's getting at is they you know, didn't go to any effort to try to find if this was Bridge Guy. Did he, you know, he didn't walk past the Hoover Harvest Store video. So where did he go? You know, going down into the woods seems unlikely because you got big search parties down there and all kinds of people. Going the other way, you never bothered to look for anything to see if that's where he went. Said it's possible that the man could have gone back to the crime scene. He could have gone the other way and gone back to the crime scene, but people are at the connector and they didn't see anything. Now, he starts to push on Sarah Carbaugh's statement because, you know, Sheriff Liggett has relied on that a lot. They all have relied on that a lot as their final bookend for the timeline. That's when Bridge Guy was leaving the area. So he asks, are you aware that Sarah Carbaugh gave inconsistent statements? And according to Sheriff Liggett, yes, they know that she just said muddy in the first interview, but then days later she said muddy and bloody. And Mr. Rosie's like, are you sure about that? And he's like, I read it in the report that she said muddy and bloody. And he's like, you're sure you're not maybe conflating that with one of the different interviews? Oh no, he read it in the report. Mr. Rosie says, is it possible she didn't see anybody that day? He just gets right down to the accusation that this could be made up. Is it possible she didn't see anybody that day? No. Nope. Sheriff Liggett, that's not possible. Not possible that she didn't see anybody. Didn't think it was odd that she took 13 days to report. Didn't realize how long the delay was, but didn't think it was odd. Wasn't told that she was panicking. Mr. Rosie asked, wouldn't you be concerned about the impact that panicking would have to her perception? And he says, no, I mean, girls were murdered. Panic isn't weird. That would be normal. Well, yes, we all agree with that. But what about the impact to her perception? Wouldn't that alarm you? Wouldn't that worry you? Don't you learn about that kind of thing in the academy? Nope. Sheriff Liggett, no worries at all. If she's panicked, she's still a perfectly reliable witness. He acknowledged there are lots of forward focuses, lots of dark forward focuses. And his car, the car is not entirely unique, this one on the video. It was really just the fact that he said he was there at 1:30 and that it's on video at 1:27. That's really the main thing. He never looked into what kind of rims come on that car, what kind of rims are available for that car. Mr. Rosie asked if it would surprise him that Ford mass-produced those rims. He said no, it wouldn't surprise him, but he never looked into it. I don't think he even knows if these are stock rims. I don't think he even knows that. I mean, it could have just been an upgrade, you know, one of those options that you get on the car when you buy a new car. He already said he bought it new. One of those options you have, you can get the nicer wheels. Later on, we see photographs of this car. We see it in the garage. I'm not like a super car person, but I kind of like cars. I drive a little sports car. I drive a Subaru BRZ. I've had it for a few years. It's a fun little car and I love it. And there was a point in time where I was thinking about like doing some build on this car. I was thinking about it. I wanted to do the intake. I wanted to do the exhaust, you know, get it, just boost the horsepower a little bit. Definitely looked at wheels. I was like looking at racing wheels and stuff. There's like some nice wheels. Okay. When you buy like custom rims for your car, these things stand out. You can spend a lot of money on custom rims. I remember one of the things that like why I never really built out my car was because I found these rims that I love. They were just gorgeous. They were these big 18 inches in like spiked racing wheels. Stunning. I hunted them down and how much they cost. They were $3,000 a wheel. Nope. Nope, not going there for my little BRZ. Wow. So you can spot a custom wheel because they're showy, and like frankly, by the time you're going to spend, you know, $500,000 on a wheel for your car, you know, you're going to get something that looks really good. We saw the photos of these rims. They are nothing fancy. They are nothing fancy at all. They're just like powder coated black aluminum rims. Very run of the mill. Very much looks like something that could possibly be a stock option for that car. Don't know, but wouldn't surprise me. And in any event, Sheriff Liggett never looked into it. We moved on to the FBI assisting early on. We acknowledged that as the investigation progressed, the team became more cohesive in the sense that early on there were lots of moving parts and just disorganization with personnel and the case management and all of that stuff. Mr. Rosie asked, did part of that disorganization include the FBI? And Sheriff Liggett says, oh no, they helped. Mr. Rosie asks, but there became tension with the FBI, did there not? Oh no. Sheriff Liggett denies that. So Mr. Rosie asks, in 2019, isn't it true the FBI was relieved of their responsibility? This was objected to as speculative. It was sustained. He's the sheriff in 2019. I would think he would know this kind of detail about the investigation. It wouldn't be speculative. He didn't get to ask. Nevertheless, he was asked, okay, Mr. Rosie is good at adjusting on his feet. When he gets these objections, he is still continuing to ask the do you agree questions. Sometimes they're objected to, and if they are, he just goes ahead and rephrases it. He's worked it out. But towards the end of the day, I noticed he's asking this, and Mr. McLeland, he's just not objecting. He's just not objecting anymore. Like, I guess, I don't know. They're saving it for just when they really want to interrupt the flow, or maybe they've just decided it's pointless and makes them look bad or something. I don't know. Didn't object to a lot of do you agrees. So anyway, he's good at adjusting on the feeds on the fly. So he asks, is there a time? Did there come a time when the FBI was no longer involved? Yes. Sheriff Liggett knows that. Well, no. He says, yes, well, no. Because if I wanted to reach out with them, I would do that. I'd be able to do that. So kind of starting to get uncomfortable. He's starting to, shift. FBI is no longer involved? Yes. Well, no, because I could get him back. He said he would be surprised if they had been told not to come back. Oh boy, is an FBI agent going to get on the stand and tell us that they were told not to come back? I wonder if they have the FBI's self-forensic person. I don't know. If the FBI is involved, there's been 2E stuff involved, and some of you in the chat may know more about that historically with this case than I do. You can tell me, was there a 2E process that we heard about in this case? I wonder. I do wonder. The first Richard Allen interview in October 22nd, that was the formal interview, the more formal interview, acknowledged that this was 5 years later, 5 years after the crime, that he had not been considered a suspect at any point up to then. According to Sheriff Liggett, he had simply fallen through the cracks. The Orion database had shown that somebody had put cleared on that tip, and that was somebody on his team. Yes, he acknowledged that. He tries to jump in, but I believe it was a dispatcher. Now he wants to point the finger at whose mistake it was. Some dispatcher. You know what this reminds me of? Pardon me for a second. This reminds me of Judge Gold blaming the clerk for all those items not landing on the CCS. Does it remind you of that? Oh, let's just find some underling that we can blame it on. There's a little bit of a code, an honor code with lawyers, where you take your own fall. It would be very easy to blame your secretary or blame your paralegal for a mistake that happens, and sometimes people do. I've seen some of that come out in like specifically. I remember seeing it real recently in these cases where people use the AI to do legal research, and they file a brief and it's got cases in it that doesn't exist. They signed the brief. It's their responsibility, but they didn't check it. But they try to blame the paralegal. Sorry, I just relied on what they gave me. Well, when your name is on it, the buck stops there. It's your responsibility. And that's kind of the code with lawyers. You don't blame your underlings for stuff that you have the ultimate responsibility for. Just thought that was kind of notable. Reminded me a lot of Judge Gold there. He said the processing of that tip, the fact that it was processed as cleared, that's the reason for the delay. It fell in the cracks because somebody cleared the tip and they shouldn't have. Mr. Rosie then goes into this line of questioning that I thought it was very effective, because he's saying, because of this delay, now delays make investigations hard. You have to go back and try to recreate what happened 5 years ago. So he's like, it's hard, right? Sheriff Liggett, now he's going to start answering the questions with the questions. He knows he's being walked into a corner. So he's going to try to evade it. In what way? It's hard. Hard to recreate what happened 5 years ago is hard. And he's got to ask in what way. It seems pretty straightforward, pretty obvious to everybody on the planet with common sense that yes, it's hard to recreate things that happened 5 years ago. Right now, spot everybody in the chat, recreate what happened 5 years ago on this day. Where were you? Yeah, right. Exactly. How far do we have to dig? How much time are we going to have to take to try to figure that out? Everybody knows it's hard. He knows he's being walked down the primrose path. So he doesn't want to answer. Well, in what way? Well, is it hard to try to remember 5 years later what you said 5 years before? Maybe it's not too big of a concern that you'd get some details wrong, that you might not remember exactly what you said. Yeah. And since delay can make it harder to recreate that stuff, then probably what some of those witnesses reported was more accurate the closer that we get to the time of the murders. Agreed with that? And before they've been exposed to all of this extraneous information. He's resistant to this. He doesn't want to, he doesn't want to acknowledge that there could be an effect on people's recollections by the extraneous information. Mr. Liggett, Mr. Rosie asks him, "You're aware the case has been covered on social media?" And he's like, "Yes, but I don't know if any of the witnesses have seen any of that. I don't know if they've seen any of the social media." They might try asking. If you're concerned about the reliability of your witnesses, you might ask them about their exposure to things that could taint them. Just a thought. Recovering physical evidence from 5 years ago. That can be difficult. Yeah, because it's gone. Because that evidence is gone. He said, "You don't know what the condition of the gun was back in 2017. Mr. Liggett says, it's not my field of expertise. I don't know how, I don't know how to answer that." So Mr. Rosie asks him, "Well, isn't it true there's no way to determine a gun that you recover in 2022? You have no way to determine what its condition was in 2017. I don't know. Mr. Rosie asks him, "Firing a gun multiple times since 2017, could that change its condition?" Well, he doesn't know. But he ultimately concedes that delay makes an investigation much more challenging. I thought this was such an important point to raise, not just because it goes to, you messed things up so bad, after all this time, you're trying to pin it on Mr. Allen. The subtext of what he's saying here is that imagine Mr. Allen trying to defend himself 5 years later. How hard is that? How hard is that? Maybe that's just my read because I am a defense lawyer. I think in those terms. But I think that was the subtext of what he was getting at. Ask the sheriff, "Do you believe Richard Allen acted alone?" Yes. Yes, he does believe that. He says he's always believed that. Mr. Rosie asks him, "You always believe that?" "Oh, yes." "But did you ever tell former Sheriff Lesenby that multiple people were involved?" "Did you ever say that?" "Well, he said it was possible." He made, at this point, what I found to be a very devastating comment. Just one of those, you said the quiet part out loud. He said, "Before Richard Allen, I was open to anything as a good investigator would be." A good investigator will also be open after Mr. Allen. You don't pick Mr. Allen and then close off your mind. That's not being a good investigator. Because what if you're wrong? What if you're wrong? Especially when, frankly, this is your evidence. This is your evidence. Car that might be his, a timeline that we're not sure what it is, a guy that doesn't match the description. Oh, and it gets worse. He acknowledges that in the video, even in the enhanced video, you can't see the man's mouth moving. So he's asking when the words are coming out down the hill. So he asks, it's possible that somebody is standing next to the girls who said the same thing? No, that's not possible. He thinks she would have caught him on the video. She would have caught him on the video if there had been somebody standing nearby. And so that's not what happened. He doesn't think that's what happened. Won't entertain it. He acknowledged they collected lots of samples. They were trying to collect DNA and stuff like that. All of the evidence has been examined. There is not one iota of DNA connecting Richard Allen to the crime scene. There is a ton of digital information. He describes cell tower information, phones, pings, tens and hundreds of thousands of pieces of data. This is, he got Sheriff Liggett to acknowledge this is extremely useful information for solving crimes. Cell phones, cell phone data, you know, in this day and age plays a huge role in solving crimes, prosecutions. And there is no digital evidence connecting Richard Allen to the crime. Now, this I thought was a good point, and it was a rehabilitative point to that problem we had yesterday, where this point was made. You know, all these extractions, including Mr. Allen's phones, his devices, and you never found anything that connected him. And then Mr. McLeland was able to come back and point out, yeah, we never got the 2017 phone. We had all these other ones, but not the 2017 one. I just thought that was a really, really low moment for the defense. It was not a good look. It was a problem. This was very rehabilitative to me because it tells me the lack of digital evidence isn't just related to what we were able to pull off of Mr. Allen's phone. They talked about the cell towers and they talked about the pings. Those are independent sources. You don't need his 2017 phone to be able to go in and get those cell tower records and find out who connected and if that included his phone. Sheriff Liggett said, and no, and that's what I thought was interesting because he said he was on the phone at the time. He wanted to make that point. I don't know what the explanation for this is. I mean, it is true. It is intriguing. It is intriguing that he says he was looking at his stock ticker on his phone, so his phone should have been connected, so there should be some record of that connection. Doesn't seem like they were ever able to find it. Does that make Richard Allen a murderer? Not in my mind. It just is a strange. Be interesting to know the answer to that. No, the absence of his phone from the network when he said he was using it to check his stock ticker, that does not equal guilty of murder. He acknowledged they don't have a time of death, that there were clothes missing from the scene that have never been recovered, that Richard Allen went to law enforcement just a few days after the crime. He pointed out law enforcement had asked for help shortly after, and that his volunteering information was perfectly consistent with that. Police asked for help, and he gave it. So nothing weird about coming forward with his story. They have found no evidence of premeditated behavior before February 13th, meaning, you know, preparatory steps, things that show he was considering this, things that show he was casing, things that show he was doing those Google searches you shouldn't do. Like, look at the Lisk case, Rex Heuermann, look at some of those Google searches, very inadvisable. Oh, that other guy over in Brian Walsh, he's the bad one, right? The other one that's over in Massachusetts, not in Canton, but a lot of the same players. He had some bad Google searches. Google searches will get you busted. Apparently none of that. Nothing like that here. He didn't flee. He stayed right here in town. Yes, hiding in plain sight. Liggett throws that in. He's adopting somebody else's words. Pretty sure that was Mr. McLeland's words in the opening. Thought that it was important, it was notable, so notable that like they called it out in the probable cause affidavit that he had backed his car. not in the probable cause affidavit, just in his testimony, that he had backed his car into the CVS lot. That was an important fact to him. So he spent some time saying, you know, 2 ways to pull in, right? You can pull in, you can back in. He modifies it. Well, actually, you could probably parallel park too, you know, but that's circumstantial. So 2 ways, 50-50 chance you might back in. And 7 years later, you're saying it's pertinent that he backed his car into the CVS lot 5 years after the crime. That's a pertinent fact. Liggett's getting defensive. No, I didn't say it's pertinent. I said I noted it. And Rosie's like, well, but you testified to it. Why would you bring this up if you don't think it's pertinent? Are you here to waste the jury's time? So he's getting warmed up now. He's really on a roll. He's starting to have fun. He starts to ask about when Mr. Allen was first arrested. He was in the jail right across the street. He's starting to talk about the capacity of the jail. And then Mr. McLeland objects, asks to approach. They approach the sidebar. Whatever they're going into is apparently sustained. So we don't get to talk about the jail and whatever Mr. Rosie wanted to go into there. He testified that there was one .40 caliber round that was recovered from the home, and Mr. Rosie says there were actually several. And the Winchester Smith & Wesson, is that a common round? He says, I don't know. I'm not much of a gun guy. The second round that was recovered from the closet, he said there was both a Winchester and a Blazer recovered from the closet, according to Mr. Rosie. Sheriff Liggett says, I don't know about that. He said, I was aware of many Blazer rounds that were taken from the magazine and sent to the lab. He said he has seen photos of the round, the recovered round, but not from the crime scene. He said he got the result from the lab, and that's when they arrested him. Mr. Rosie's like, you wouldn't have arrested him without that bullet. And he said, no, I couldn't say that. I couldn't say that. And Mr. Rosie's like, you know, what else did you have? He's like, we had Betsy Blair. We had, the 3 other girls, the timeline, da-da-da. Mr. Rosie's like, Betsy Blair saw a boyish man, and he was in his 40s. She saw a man with brown, poofy hair. Gold moment here. Sheriff Liggett says, well, all the witnesses described him a little bit differently. Mr. Rosie says, is there something wrong with just believing what Betsy Blair said that she saw? Do you think she's credible? Yeah, he thinks she's credible. You're not supposed to ask that question. But they did. Yeah, he thinks Betsy Blair is credible. Her description doesn't fit Mr. Allen. Sheriff Leggett's like, well, yeah, but neither do the other 3 girls. Mr. Rosie goes, right. That's right. None of the descriptions match up. He walked right into that. It was just an oof moment, and he realized instantly. He walked right into that. Yeah, that's what you got, that you're hanging your hat on. 3 or 4 descriptions that none of them are the same. And at least 3 out of 4 don't sound anything like Mr. Allen. McClelland asked about the significance of the bench photo on the direct examination, and they agreed it was very significant to the timeline because they had seen Bridge Guy shortly after that. Mr. Rosie points out the photo was taken at 1:26, but the car was in the video on 300 North at 1:27. Doesn't it seem implausible that would then that they would be able to work that out? They would have had to have hung out at the bench, I would think, for quite a while, because he's got to get all the way over to the CPS lot, park, get out, and then he's got to walk all the distance just to get to the main trailhead. Then he's got to come up the trailhead, cross the Freedom Bridge, and start to head into the wooded area. That's where those witnesses testified they saw him. He's got to make it all that way. Meanwhile, they're at the bench at 1:26. This is a good point, I thought, on the timeline. Sheriff Liggett says, well, maybe they left the bench at 1:44. Now Mr. Rosie is getting mad. He says, that's you just making stuff up. And Liggett's getting mad too. I'm not making it up. I'm absolutely not making it up. It's on video. Really? Is it? Is it? 1:27 is on video. Maybe they left the bench at 1:44. Oh my Lord. This was not a good point. He has clearly presented himself now as so fixated on Mr. Allen that he's in the cognitive dissonance mode, where you get conflicting information and you will literally make things up, imagine things to be able to reconcile reality with what you want to believe. Oh, the timeline doesn't fit because the car is at 1:27 and the girls are at the bench at 1:26 and they saw him shortly after, and it would take him more than a short time to get there from that position. Well, I'll just imagine that they left the bench at 1:44. Wild. Absolutely wild. And just, he's already demonstrated this with, no, it's not possible that Sarah Carbaugh didn't see anybody on the road. No, it's not possible that a different person, somebody not the bridge guy that didn't get caught on camera, said guys down the hill. None of these things are possible. He's extremely closed, and that is exactly the opposite of a good investigator. So he really revealed himself in this testimony. Pointed out there were actually 4 girls on the trail. Richard Allen said he saw 3. Betsy said she saw 4. Might not even be the same people. We might not even be talking about the same people. Let's just consider, hypothetically, Richard Allen really was at the trail in more of the 12 to 1:30 kind of time frame, and less the 1:30 to 3:30. Whole different set of people there. And that would explain why nobody else saw him. They didn't see the same people. That's why Bridge Guy doesn't look anything like him. Kind of starting to seem pretty plausible after all of this. He acknowledged he'd listened to the video, that enhanced video over and over and over and over again, and that people had sent him in the tips all kinds of different interpretations of what was said. All kinds of different interpretations of what was said out there. He started to explore this idea that witness unreliability, eyewitness unreliability. He uses this example of somebody that you think is creepy. If you get like a creepy reaction to somebody, you might describe them as being dressed all in black, but it might not be true. So he's just pointing out, and Sheriff Liggett is like, you know, where are you going with this? And he's like, well, witnesses can be unreliable. Don't you learn that in the academy? You learn that in the academy, that eyewitnesses can be unreliable. And Sheriff Liggett says, well, just because it's different doesn't mean it's unreliable. Just because the descriptions of ostensibly the same person are all different doesn't mean they're reliable. So the man looks like 4 different people. They're all reliable. The man is simultaneously 30, 40, 50, and in his early 20s. He simultaneously got poofy hair, curly hair, and a hat on. He's simultaneously muscular and like not notable in his build. It really went off the rails for Sheriff Liggett. Really went off the rails. Final point, McLeland had asked him about the gun. Isn't it true that they were already looking for either a Sig Sauer or a Smith & Wesson? Because the lab had told them already that they would be able to match the extractor marks to those guns. No further questions. He did such a masterful job of showing the reverse engineering of the case against Richard Allen. They took what they had and they got their tunnel vision on him, and they went out and found whatever they needed to do to make it fit. And they didn't bother to look for anything to test their hypothesis. They didn't look to see how many Ford Focuses were registered in the county. Oh, that to me, big oversight, big oversight. And I really, after hearing this testimony, yeah, I don't think it was even like a deliberate choice. We're not going to, because we're going to frame him, honestly. Because sorry, but after seeing all this, they're not that smart. They're not that smart. No, it literally never crossed their mind. Because they were so focused on Richard Allen, they decided it was him. They'd already surmised it was his car. Started seeing weird things in backed-in parking. I mean, this is a lesson in confirmation bias right here. This is like. This is just classic. And yet, they think they're these good investigators. Wow. Masterful performance by Mr. Rosie, in my opinion. Mr. McLeland went back to the bullet that was found in the Hope box and clarified that was a .40 caliber Winchester, and that Sheriff Liggett only knew of Blazer ammunition in the magazines, didn't know of any other .40 caliber ammunition in the firearm. It was just Blazer. Only knew of the magazines. There were other magazines with the gun, and to his knowledge, no other .40 caliber Winchester in the house. So that will be interesting to see if that who had that right. Agreed that the memory is better closer in time than 5 years later. He's questioned about that on cross-examination. This this was good by Mr. McLellan. This was good. He flipped the script. So in your opinion, isn't Mr. Allen's memory also better, closer to the time of the crime than it would be later? That's to try to get him back to the timeline. That's to try to get him back to the timeline. It was clever. It was clever, but I don't think it was enough. Mr. Rosie did his recross then. So what Betsy Blair said she saw on the bridge that day, she said it the same day. If this is our standard, that's the best evidence we have. That was good. That was good. I mean, this was a real back and forth, real exchange. This is why I'm saying we're getting into the street fight mode of this trial. They are exchanging. He started asking about some of the results from the tool mark testing that was done on the bullets in the firearm. I wasn't quite clear exactly which he was asking. He was saying no exam between the firearm showed sufficient agreement between any of those rounds. The rounds weren't fired. So I didn't understand what he was talking about. It got objected to anyway because he doesn't know. He was trying to get it out of Mr. Liggett, as you know, because you read the report. But he's not really the witness for that. They're going to have to do that. They're going to have to do that with the examiner, with Melissa Oberg. He just clarified that the box was being characterized as a hope box because he described it. It was a wooden box that had things in it. And he asked if the marks on the round in the box, the hope box, this round, and the firearm in Mr. Allen's house, were those connected? That was interesting. Good point. He didn't know. He didn't know. I wonder if they tested that. Because if it's not a firearm from that gun in the hope box, then it doesn't really matter. Does it? If it's a hope box, I mean, I could think of different reasons why you might have a bullet in your hope box. I'm not sentimental about much stuff. Generally, you know, I don't really collect a lot of things and like hold on to old things. But I know a lot of people do. And this guy, you know, he clearly fishes. He's got an outdoor culture, has handguns. I can think of different reasons why there might be sentimental value to something like that. The jury did not have any questions for Sheriff Liggett. This jury that asks all kinds of questions. Yeah, they had none for him. They had heard enough. We moved on to ISP Detective Dave Vido. He was on duty during the search warrant execution. He was there to assist in the search, and he witnessed photos being taken during the search. So the bulk of his testimony was just getting in photographs of what was seized. So this is where we saw the photo of the car, of Mr. Allen's car, where you can see the rims, and it's like, okay, yeah, they're spoked rims, but there is nothing fancy whatsoever about these rims. Like they don't look custom. They look like you could probably get them as an upgrade on your car. That's my view of it anyway. They found tons and tons and tons of knives. Like all over the place, in the workbench, in the garage, in the kitchen. Found a couple box cutters. They found a plastic bag with a bunch of chargers in it. They found a whole bunch of phones and pagers were the devices in the office. He made a point of saying the only one they were not able to collect was from 2017. We had a photo of them. He says there was like 14 of them and more that were found in the bedroom, but were not in the photograph. So like 2 other flip phones. So about 16 phones, that they found. That is a lot of phones, and that does still concern me a little bit. You know, after that moment we had yesterday, I was like on high alert. Well, God, it's going to be so bad now if they have a ton of phones and the only one that's missing is the 2017. And there's a lot of phones in there and not a 2017 one. So could be an issue here. Here's something that was very important as well, I thought. The 40 caliber round that was inside the box, we specified now it's a hollow point. It's a hollow point round. It is not a full metal jacket round. What's the one out at the scene? We sure couldn't see in those photos that they took of the thing lying on the ground. We couldn't tell if it was a hollow point. So that I thought was notable. Winchester ammunition is like so common. You can buy it at Walmart in some places. They seized, one of the other things that they seized that was interesting, I thought, was they had a photo album that was out they found it in the spare bedroom, and it showed photos of Mr. Allen and his family being out in the High Bridge area, being out on the trails. The entire family went there. They had photos from as early as 2008. Specifically, they photographed photos of Rick at the trail. He was at a picture of him at Deer Creek, picture of him fishing, a picture of him just out in the woods, out hiking, all in the 2016 time frame. So the jury gets to see what he looks like pretty shortly before these murders. Ms. Auger did the cross-examination. Oh, she had fun. She had fun too. She starts off, "Don't you agree that a search must be done to professional standards?" She has a little bit of a high-pitched voice when she wants to really have fun. And she confirmed, you know, he was there for the photographs. You want them taken in a professional way. And they had photographed the bullet end of the cartridge in the box where it was found. They also photographed the other end. And she brings up the photograph and shows him. Someone is holding the bullet. Somebody's holding the bullet. And they photographed it that way. And she's having fun. "You wouldn't want to damage it by photographing it, would you? Is having a hand in the picture unprofessional?" Oh, she got him good on that. Their own photo. They're holding the bullet after they tried to say that. And he's like, "Well, I don't know how they'd do it otherwise." And he concedes, yes, it's not actually unusual to hold an item in order to be able to photograph it properly. He doesn't know who took the photo. He knew lots of people that went to the High Bridge Trail. He knew Betsy Blair went there, Rayleigh Voorhees, Bree Wilbur, David McCain. He knew that the trail has been improved. He's seen the Delphi signs. He's not too sure if Delphi advertises the trails, and he's interviewed people here who've never heard of the trails. But basically, they're just establishing that it's really not uncommon to be out there on the trails. Like, this is not something strange for Mr. Allen's family to be doing. In the middle picture of Mr. Allen in 2016, he had short hair. You couldn't tell from the pictures if he had curly hair. He watched Mr. Allen's interview, the police station interview, from a video in a video feed in a different room, but he don't recall what his hair looked like. Looked at all these pictures of all these knives, points out, are you aware he has a fishing license? and that it's not unusual for fishermen to have knives. He says he doesn't know. He doesn't know fishermen. She's like, well, do fishermen, would they use knives to cut line? He says, well, maybe, but maybe they would use scissors. I had a big LOL at that. Big LOL. Fishermen using scissors to cut their line. Has anybody ever seen that in their life? I don't think I have. I don't think I have. No, you have your fishing knife. You have fillet knives. You have. It would not surprise me that an avid fisherman would have a lot of knives. He also agrees it's not uncommon to have box cutters. He agrees that people frequently recycle their phones. He said that it appeared that they had kept a majority of their phones. Ms. Auger points out they even had pagers. These things went back for years and years, but they don't know if they changed their habits over time as far as, like, you know, recycling your phone or trading in your old phone or something like that. He was not sure if lots of people have either blue Carhartt jackets or Sig Sauer guns. He wasn't aware or wasn't sure that other Sig Sauer guns had been collected in the course of this very investigation. Oh, I can hear Ms. Auger in her sing-song voice. But other Sig Sauers were collected in this very investigation. He was assigned to the case temporarily in 2019, and so he went through evidence as best as he could to get caught up. She's trying to kind of call him out on, you know, didn't you review the evidence in this case? Aren't you familiar with it? So he's just basically saying he did the best he could, but he's maybe not, maybe doesn't know everything. So we go through. The jacket was sent to the lab. It was tested. He's not aware of any link to the girls. They seized his car, not aware of anything inside his car that would be a link to the murders. Just the fact that, according to him, the car is on the Hoosier, I'm going to keep saying that, Hoosier Harvest Store video. And that it's matched, but that matches just by the look and the time of the vehicle, not the license plate. So a similar vehicle at the time they really want Rick Allen's vehicle to be there is the reason why it's a match. He doesn't know if there's a lot of Ford Focuses out there. No idea. Nothing tested inside the car was linked to the murders. Not a single knife was linked to the murders. He acknowledged there's clothing missing from the crime scene, specifically a girl's sock and a girl's underwear. People searched his house so thoroughly that they used metal detectors and dug up his yard. They did not find these missing clothes. She goes to Sarah Carbaugh's statement about a man walking on 300 North that he was covered in blood. And is he aware that blood transfers? He says, yes, he's aware of that. She says, are you aware that you can test for blood years later? Well, now he wants to backpedal. It was described to me that the blood could be dry. Could be dry blood. Like moments after the murders. Ms. Auger says, do you not know if dried blood can transfer? No, he doesn't know. He doesn't know if dried blood can transfer. At this point, Mr. McLeland objects that it's beyond the scope. She asks a question, whoever killed the girls probably had a lot of blood on their clothes. Mr. McLeland objects at this point to beyond the scope. It's sustained, and Ms. Auger sits down. We then get Jerry Holman. He is our final witness of the day. So he's going to be called in pieces. We heard about this just when we came back from the recess. It's going to be like Miss Officer Mullen, where they just kind of bring him up when they have something particular and then let him go and bring him back. So he was the He is the ISP investigative commander. He was there to testify about assisting with a search warrant on October 13th. He says first they walked through and they photographed the property, and then they sat outside while the search was happening. Richard Allen was sitting in his car, so he had some talks with Richard Allen. So they said he told him They told him that if they damaged his property, there's a form that he can fill out. If there's a locked box, they'll bring it over to you so he can try to open it. And Mr. Allen said, "It doesn't matter. It's over now." And then later, when they were out in the car, he was getting out to smoke from time to time and stuff. And he asked if they had detained his wife, and they said no. So they then said, you know, they would drive him to her if he wanted to see her. And again, he said, "It doesn't matter. It's over." So he's free to leave at the end. They saw the gun. We got my favorite part of the trial, of any trial really, with Jerry Holman, and that is our evidence handling theater. If you watched the Karen Reed trial with me, you know exactly what I'm talking about. It's this theater where they go in and they put on the gloves and then they touch everything under the sun and touch the other pieces of evidence with the same dirty gloves. It's theater that they stand in there and pretend that they're doing something to prevent cross-contamination. So we saw that from Mr. Holman. He really committed to the bit too, because he put on 2 pairs of gloves, right? The gloves over the gloves. But he spent so much time, he was having a hard time getting the first pair of gloves on, that he is literally like manhandling these gloves all over with his bare hands. Who knows when he washed them or if he sanitized them or anything. All over his bare hands, and then, you know, gets the gloves on and then is handling the other gloves and grabs them. Then he is grabbing a box out of a box, some other box out of a box, grabs the evidence box itself, grabs a pair of scissors out of the box. Who knows who has touched the scissors, uses these mysterious scissors to open up the box, pulls out the gun with his hands that have now like touched half of the things in the nearby vicinity, and uses that to display it to the jury. Really nothing of, you know, evidentiary importance about it. There's a gun. We know there's a gun, but we got to have that theater. That theater. We seem to have some, I mentioned it yesterday, some technical-minded people on the jury, some scientific-minded people on the jury, just with the types of questions that they've asked, and some of the language that they've used just implies maybe they have a little bit of knowledge, a little bit, you know, greater knowledge of some of these things. And I just wonder, you know, if there's scientists on the jury, are they looking at that with the same kind of amusement that I am? Like, have they noticed? Have they noticed this is just theater? Because you're not actually preventing contamination from your handling practices. Oh, and he also flagged the jury and the audience while he was displaying the gun. They, Mr. McLeland specifically asks him, "Can you please clear the weapon to make sure it's safe before you display it to the jury?" So he points it. I couldn't see exactly where he pointed it. It honestly looked like he was pointing it kind of towards the bench, and it racks the slide a whole bunch of times, rack, and then he's showing it sideways to the jury. He's walking past the jury box, and as he is, he's turning it, and it's like flagging the people that he's just passed, and then he goes to put it back in the box, and he flags the audience with the gun. These are just little things that I notice. That was all he was there for at this point. Mr. Baldwin did his cross-examination. So he acknowledged that this search was just a few hours after Mr. Allen's 1013 interview, and that Mr. Allen was a suspect during that interview, and that he was aware that he had been accused of killing the girls at that point in time. He reiterated that, he visited these statements in the car and got Mr. Holman to say that he had a recorder on him at all times because he's got a cell phone, you know, if nothing else. But Mr. Allen made the comments to him voluntarily. He chose not to record it. So we are, again, to rely on his account. He had asserted his innocence earlier, acknowledged that during the interview. Asked if the street was completely blocked during the search. He said, well, not completely blocked. I think maybe cars could get through. Makes it clear like what a scene this was when this happened. He knows he's accused in the interviews, knows he's accused of killing these girls. Asked him, his demeanor didn't look like someone who had killed 2 girls in the interview. Didn't look like the demeanor of somebody who had killed 2 girls. Don't know. Mr. Baldwin, he wants the jury to be able to see the videos. He wants them to be able to see the video. And I don't think they're going to be able to. I have some suspicions about why that is, but he makes sure to keep bringing it up, and what a good piece of evidence it would be, because then the jury would be able to see his body language and the tone that he used and all that type of thing. Mr. Holan agrees with that. He's making it clear to the jury that this would be good information for you, because I don't think they're going to see it. So it's just to make a little mental note. State's keeping this from you. My suspicion why it's being kept out is that when the party opponent wants to introduce a person's statements, so the state wants to introduce the statements of the defendant, they're allowed to do that. It's an exception to the hearsay rule. But when the defendant wants to introduce his own statements, it's not an exception to the hearsay rule. So this is something that prosecutors will do. Well, they will again cherry pick pieces of evidence, pieces of statements like out of an interview or something, and then object when you try to introduce other pieces, other statements from the interview. So the best like objection to this practice is really what's called the rule of completeness. And it's just a general evidentiary rule that if somebody is going to introduce part of a statement, then the other party can request to admit any other part of it that should, in fairness, be considered along with it in order to give you the full picture, put it into context. So that's really the best way around this objection that I get to use your statements and it's fine, but you try to use them in their hearsay. Some judges will allow that and some will not. Do you think Judge Gull would allow it? Do you think if Nick McClelland is objecting that she's going to allow it? Yeah, no. That's my suspicion about why they are not going to see this interview. And why Mr. Baldwin is highlighting what a good piece of evidence this would be for the jury if they were able to see it. He points out during the search, everybody in the neighborhood would have seen what was going on, right? We already established that the road, it's not completely blocked, but it's blocked. He objected to that. McClelland objected to that. That's speculation, whether the entire neighborhood would have seen it. That was sustained. So the box was opened at least 3 times. It's on the box, but it's hard to read. Mr. Baldwin is looking at the box and he says, well, I only see one signature. So at this point, Mr. McClelland asks to approach. They have their sidebar. And then the judge gives an instruction to the jury that the parties have stipulated to the proper chain of custody of the gun. So she doesn't like him raising these issues about handling, because these are items that they stipulated to the chain of custody to. That, I suppose, is kind of fair. I mean, I could see an argument that you can still impeach the investigation and the handling practices generally without saying it makes this gun inadmissible. But she's not letting them go there, and then she's giving them this instruction. It's not the first time that she's done this. He brings up Sarah Carbaugh. There's an objection to being beyond the scope. That's sustained. He then asks, nothing wrong with photographing a bullet in your hand, the way this photograph was done. And Jerry Holman says, well, it depends, because a bullet can be damaged by handling. And if it might have DNA or something like that, you want to limit the handling of it. So it's, best to just put it in that secure container. And then the lab should photograph all three sides. So he says, yes, it should be the lab that does that. And then that was that. That was his testimony. That was our conclusion. So I'm wondering if we're going to see photographs of all three sides of the bullet from the lab. We'll see. I then watched him take the box into his bare hands and walk it back to the evidence table after all of that theater. That was our day. It was, from my perspective, a very good day for the defense, because this was really the state's first exposition of here's all the reasons why we're suspicious of Richard Allen. And I thought the defense did a really good job of making a lot of it sound really ridiculous. You're suspicious because he backed into a parking space 5 years later. I mean, my goodness. My goodness. That is something else. And the witnesses, especially Sheriff Liggett, didn't help themselves. You could not draw a more accurate caricature of an investigator who's got tunnel vision and is closed off to any other possible explanation, any other possible theory of the case. He's decided what it is, and that's that, to the point that he will make stuff up. He will imagine things that he can't prove. Just dream them up to be able to reconcile what he wants the situation to be with what the reality of the evidence actually is. Very, very good day for the defense. All kudos to Mr. Rosie in particular, because he is the one that really drew that out of Sheriff Liggett. He is the one that got Sheriff Liggett to show himself for being this closed-minded, prejudged investigator who's not interested in following the facts. He's interested in finding the facts that will support his theory. The ones that don't, never bothers to look. That was very, very powerful. Very powerful. So with that, let's go ahead and get to some of your comments and questions and so forth. We have Della Swincher is now a new member. Thank you so much for joining us. Jay Beans, my question is that if they were able to get pics of cars and geofences of witnesses and contact them, where are the pics of Muddy Bloody Bridge Guy? She passed him on the road, allegedly. Thank you for being our eyes. You're very welcome. It's a great question, and it's the one that it came up. It came up. Somebody mentioned the gentleman I was sitting next to in court today. Very nice man. He was a school teacher from Connorsville. Came up to watch the trial. They're on fall break. Had some nice chats throughout the day. But he had an excellent point. He was asking, are the cameras, are they motion detection cameras? And I said, I'm not 100% sure. I sort of thought they were. That's just kind of what it sounded like. They never explicitly used those words, but I do remember them saying that the camera will, photograph the cars when they go by. It's just an impression I got. But if they are, he pointed out, well, it might not be enough for a person walking by out in front to trigger the sensor. And so that's possible. That's possible. I just don't know if we have enough information about that to be able to say one way or the other. But that's definitely a good point, and it is a possible explanation for why the bridge guy would not have been on the camera. I find it implausible that somebody would go and murder two girls and, according to these people, try to conceal them but then walk your bloody self down this street that is probably kind of high traffic because it's such a beautiful day and every person and their dog is out there on these trails. You're going to walk down that road in front of the entire world covered in blood after you just murdered the girls. I find this very incredible. So I really don't think that that happened. I think that either Sarah Carbaugh saw somebody and has been, tainted by the subsequent information. It's possible she didn't see anybody at all. I wouldn't want to assume that, but I'd have to concede it's possible. But I just find it highly unlikely that a bloody person walked down the road in these kinds of circumstances. The fact that, yes, the camera didn't catch him, that's not a helpful fact for the state for sure. Truth and transparency. I got us covered on pens for Monday and Tuesday and pads for the week. My only question is, are you a beer or wine drinker on the weekends? I'm not going to be drinking probably anything this weekend. I'm going to be sleeping. And I am going to be working on whatever follow-up I will be pursuing on this order that is denying my motion for the public access. My weekend this weekend is fairly allocated. Other weekends, I'm not that picky. I'm not a huge drinker, but I'll drink a beer. I'll drink a glass of wine. Sometimes I'll drink a Manhattan. I like a good Manhattan. Oh gosh, if I can find a good French 75, I do enjoy that, but not a whole lot. Karen H., I'm so glad to follow your streams. Thank you. Well, thank you for being here with us. I'm glad that there's so many people interested in the details that I am able to bring to you. Two blue crayons with a super sticker. Thank you for that. Jim Green, thank you, Andrea, for your superb coverage of this case. In your view, does the investigation appear to have tunnel vision? For example, the medical examiner changed his view on the type of weapon 6 years after his autopsy. Yeah, and after having apparently numerous conversations with the prosecutor between the time of his deposition and the time of his trial. And I just am so curious to know if at any point in any of those conversations it was mentioned to him that Richard Allen confessed to killing the girls with a box cutter. Really would like to know that piece of information. Under the standards that have kind of been set for the asking of the questions right now, I don't think we would be allowed to ask that question because the fact of Mr. Allen's confession, even though we know it's coming into evidence because the state has promised us in their opening that it's going to, and since that's pretty much the high point, the peak of their case at this point, we know they're coming in. But because it's not in yet, they wouldn't be allowed to ask it. So part of the gamesmanship here, I think, too, is that we have limited time here. Judge Gohl has put the hard outside limit on when this trial is going to conclude and go to the jury. So the defense is going to have limited time to be able to do what they need to do. That means that the more they can be tied up with potentially having to call people back in to chase down these loose ends that they're not being able to address at the time, that's going to suck up their time for putting on their defense. So I think that's part of the strategy here, part of the reason why this whole beyond the scope objection it's so technical, pointless. That's why these are being upheld. So yes, after today especially, it could not be clearer to me. This is a tunnel vision investigation. They had nowhere to go. Somehow this original piece of information that was originally cleared, and we don't have any explanation for who and how and why this was originally cleared. I don't know, maybe somebody looked at it and realized he doesn't match the description of bridge guy, cleared. Just possible. But they just went and hunted it down and then looked for what they could find to try to build it up. That just seems very, very clear after today. Choose Hope. Thank you for sacrificing so much to keep us informed. You are amazing. Well, my pleasure. I keep saying it's kind of an adventure, and it really is. We're kind of getting used to the whole hardship part of this trial. You know, the little sleep, um, the rules constantly changing. But I really feel like everybody's kind of keeping a positive attitude. Everybody is so far, you know, we're not at each other's throats, even though I'm pretty sure that's what the judge is trying to get us to do. She's trying to get us to she's trying to, you know, pitch us against each other. And so far it's not working, and I find that very gratifying. Catherine Joy, Andrea, love your podcast. You are a super woman. Well, thank you so much. I really am I'm just a person. I'm not just a person who went to law school and did this for a while, and now I'm not doing it anymore. And so I thought it would be fun to talk about these cases that I'm interested in. And lo and behold, all you folks are interested in it. It still amazes me a little bit every time, but I really appreciate you saying that. It's very gratifying to hear. BLT with a super sticker. Thank you so much for that. Dr. Tiny Toff, how biased and unfair does a judge have to be removed from the bench? Thank you, Andrea, for being our eyes and ears and for making a public record of what's happening in that courtroom. Well, that is what I'm here for. Public courts are extremely important to me. My view, I will just repeat, I say this a lot, the courtroom is our courtroom. What happens in there, it is done in our name. That prosecuting attorney who represents the state is representing us. So we have every right to be interested in what they are doing in our name, because on some level, ultimately, we're responsible for it. So yeah, we get to know what's happening in there. So judges getting removed from the bench almost never happens. And judges are biased all the time. I don't know that I've ever seen a judge get removed from the bench for being biased. The only judge that I remember offhand seeing be removed from the bench is the judge, Judge Galena, Scott Galena over in Asotin County. Look him up. Because I probably can't say the details on the stream without the stream getting taken down. Let's just say he was convicted of crimes relating to certain behavior that he was engaging in with the entire court staff, like to such an extent that they would have to, they had like rules so that they would not be alone with him in a room together and so forth. Yeah, that guy got removed from the bench. That's about what it takes, though. It's about what it takes. It takes something pretty severe or, you know, mental breakdown. The thing is, a lot of people in that kind of position will just resign. You know, if you're in like a bad personal situation, you're not coping well, a lot of those guys will just resign. It doesn't get to the point of getting removed. Committing a crime will do it. Very, very hard to get a judge removed from the bench. Why? Because the people who decide whether the judge should be removed from the bench are other judges. Most of the time. A to Z, huge new fan of yours and your very balanced and pleasant coverage. You are a gem. Well, welcome. Glad to have you here. Glad you like what we're doing here. I describe what we do here as ASMR, Law Watch. You know, we get enough stress throughout the day, and these trials can be very stressful processes. You can get very, very caught up in it. My goal is to just try to bring some of that back down, bring us all back down to earth, make it comprehensible, make it understandable, just make it something that doesn't have to stress us out so much. We can understand it and we'll get through it together. So I'm glad to have you here with us. Catherine Joy, can I buy a membership? You sure can. I'm not the best person to tell you how to do it because I know that there are tricks when it comes to the iPhone. The iPhone, if you're on a phone, makes it difficult to do it. But if you're on a web browser or on an Android phone, there should be a button somewhere that says join. And if you just hit that button, that's what lets you become a member. So I would suggest if you're on an iPhone, you don't see the button, just go to a desktop or laptop or something like that. Go to a web browser, go to my channel, and you should be able to find that button and join. And we would love to have you. The Squid, if Mr. Allen is innocent, let this be a lesson to never talk to cops, especially if they read you your rights. Oh boy, yeah, no kidding. At that point, that's a tell. This is what we would call a tell. When they tell you you have the right to have an attorney, then exercise that right. Exercise that right. When they tell you you have the right to remain silent, you want to exercise it. You really do. You really do. Just the unfortunate thing about this case is that it really is sad that it is discouraged. It is going to discourage good Samaritans. No good deed goes unpunished. And boy, has this man been punished. Boy, has this man been punished. If he's innocent, Maria, thank you for all this coverage. You are very welcome. Thanks for joining us for it. Brandon McRoby. 1, please file an OA. It is on my radar. 2, judicial bias. Yes, but there is no recourse. 3, has defense hired a pathologist to perform an independent autopsy? I believe so. I mean, not an independent autopsy, but I think a review of the original autopsy. I would suspect that they have. I would expect that. Although, if they didn't know that this medical examiner was going to change his opinion about all of these other things, maybe they didn't. Maybe they didn't. Maybe they're going to try to get on that now at the last second. I'm not sure. I feel Judge Gold knows she is under your microscope and is intimidated. She is on trial in the court of public opinion. I wouldn't be surprised if she knows, that I have been highly critical of her on my channel. I wouldn't be surprised about that at all. I don't feel like she's treating me special. I will say that. Like I'm not. Look at how she's treated these defense lawyers. It's just kind of her style to be dismissive and contemptuous and arrogant. That's just her style. Well, maybe we just need to see if that holds up. Trianne Quick with the straight super chat. Thank you so much for that. The crypto tax lawyer. Oh, Andrea, I can't even with this quote trial. Used to do family law and criminal defense in small southern towns similar to Delphi. Yep. I can relate to the small town trial and the aggravation that you see in some of these circumstances. This is Hurricane by Bob Dylan. Great reference. Indeed it is. God bless you, fellow female esquire. Thank you. You are very welcome. Yeah, and that's the thing that is kind of hard about cases like this. It's, for me, I just love seeing so many people here that are recognizing this is wrong. This is wrong because for so long in my career, such a big part of it, yes, I spent them in small communities. I dealt with judges like this. I dealt with trials like this. They feel like railroadings. And I dealt with juries that ate it up. They just ate it up. They don't care. They loved these implications. Oh, he changed his height and his weight. That's consciousness of guilt. They'd be like all over that. It's just, there's so much injustice in so many places. And so the fact it's like, it's a perspective check for me, to remind me that those may be outliers. I could have practiced law in the outlier places. Most people don't actually see it that way. Oh man, that's a perspective shift. That like brings all kind of hope back to me that maybe we can fix this broken system. Maybe we can make it better. because we do have people that care about justice and care about fairness. It's just a great thing to see. K, based on Goal's response to your motion, particularly regarding the audio, does that mean Richard Allen and / the defense can request them? Yes, they are entitled to request the audios under her interpretation. Now, the issue I have is that the rule she cited is a civil rule. It's not the rule for criminal cases. The rule for criminal cases doesn't say anything about only the attorneys can request it, the public can't request it. And the thing is that this distinction makes it makes some difference. It makes sense because there is some distinction in the case law, possibly, between the First Amendment right of access when you're talking about a criminal trial versus when you're talking about a civil trial. The U.S. Supreme Court has made it absolutely crystal clear the public cannot be excluded from a criminal trial. We have a right of access. But they have never said that about a civil trial. Now, some circuit courts of appeal have said that, but the U.S. Supreme Court has not, whereas they have with the criminal. So there is at least a conceivable justification for why you would treat these things differently. Civil cases, they're just largely private disputes between people. It's much more common for them to be, shielded by protective orders or information that's, that's like trade secrets or things like that are entitled to be kept out of the public record. So a situation there where the public isn't necessarily entitled to the recordings, I feel like that can be reconciled with some of those practices and some of those constitutional principles. With a criminal case, yeah, not so much. Not so much. So when you have a criminal rule that addresses audio recordings, and it doesn't say only the defense can get them, only the parties can get them, and you combine that with a public records rules that say court records, you have a right to inspect and copy them. When you have a recording that's a court record in a criminal case, yeah, I think we get it. So that's my view on it. But yes, even under Judge Goal's interpretation, Richard Allen and the defense would be entitled to request the recordings. DB, what is the most egregious legal issue you've observed thus far? I mean, for me, it's still the exclusion of the third-party culprit. It's the exclusion of the third-party culprit. Even, I keep saying, even by the direct link standard that they seem to apply, which is constitutionally problematic because you're putting a higher standard on the defense's ability to present a case than you are on the prosecution's. They just get to present whatever is relevant, but you have to present relevant plus, even though you're the one that has the constitutional right to present the defense. I think having a higher standard is constitutionally problematic, but even under that standard, I don't know how we haven't met it here. I don't know how we haven't met it here with people that are implicating themselves, implicating their colleagues. Yeah. That's the big problem for me. I'm also really baffled by the geofence exclusion, because I don't understand it. I learned that on criminality, I'm gonna have to go check it out. Apparently they got the transcripts, they did a whole big read through. And so I want the transcripts from the evidentiary hearing where all of these things were hashed out. And so I don't know if I'm going to be able to do it this weekend. Maybe it'll, be the following weekend. But I really do want to get caught up on that because this geofence ruling has really bothered me. All I know about the basis for this ruling is that it was decided it was unreliable because the cell tower covers the whole town. I saw the cell tower tonight, by the way. We got out of court a little bit early. And so it was a beautiful afternoon. The sun comes out. It's freezing cold in the morning, and there's like all this fog coming through and stuff. It's like honestly a little spooky looking, but by the afternoon, it's beautiful. And so we got out a little bit early, and I'm like, you know what? I've been hearing all about this canal that's like just a few blocks away from the courthouse. I'm gonna go ahead and take a walk down there and take a look at it. So I did. Uh, went ahead and took my walk down there, and yeah, it's a canal. We got a lot of canals where I am. It's a canal, but it's they got trails along it and benches and lots of this is big, beautiful, deciduous tree country, and the trees are all it's probably about peak color right now. So it was very pleasant. But anyway, I could see what looks like probably the main cell tower in town from right there. It's like this one big tower. It's got a whole bunch of different cellular installations on it. So that's probably the one that we're dealing with here. Anyway, the whole justification apparently being that it's unreliable because the cell tower covers the whole town. But geofence data is typically far more than cell data. It's satellite data. It's that location services stuff that we heard about. We heard a lot about that from the experts yesterday. We get to hear about it from them, but we don't get to hear about it from the defense. Yeah, that's a problem. So those things, are pretty close for me. These evidentiary things, it's hard to say like they're particularly egregious because it's the cumulative effect of them that's the problem. It's not any one in particular. It's just the fact that it's over and over and over and over and over the defense is obstructed, and they're not allowed to do things that the state is, and the state is allowed to have it both ways, And so the only real, I guess, comfort I get from that is, yeah, I really do. I really think we have to be at the point where surely the jury is noticing this. Surely they're noticing this. I mean, the object when you read the transcript, object when you don't read the transcript, like within minutes, like a few questions apart. That's just hard to miss. It's hard to miss. So I think the jury's seeing it, and I hope they take that into account. And I hope that they are getting the picture here, getting the point that it's the state that's keeping you from seeing stuff that would be helpful in making your decision, in figuring out what happened. Marcelo, Bev and Gull are so similar, sustaining "this hurts my case" objections. Judge Azkarati, we miss you. Oh, isn't that the truth? If he gets convicted, I'm certain this trial will be overturned. Hopefully the jury is smart enough. Yeah, I don't have a lot of confidence at this point in a verdict, a judgment of conviction, sustaining an appeal, and my concern, I mean, I'm not the only one that's concerned about, what's going to happen with Mr. Allen, his safety and stuff like that, because in many respects, the best possible thing that could happen to the state would be for it just to, find a way to all go away. Not going to say it in a way that could get the stream taken down, but you know what I mean. You know what I mean, because that lets them stay in this confirmation bias mode where they got the right guy and they solved it, so they're excused from having to go out and start over from square one like they would have to do if he's acquitted. But they don't have to go through the burden of convicting him in a fair process. Yeah, I don't have confidence in a judgment of conviction, but I am hopeful. I really am. I'm hopeful that the jury is seeing this. There were just so many good good comments during the jury selection. You know, a lot of recognition of the importance of the presumption of innocence and the state's burden, and how you really do need to be real certain in a case like this. And I just really hope that they carry that principle through to the end of this trial. Jojo, when you're all done leaping over tall buildings and balancing the scales of justice, you should definitely look into writing fiction law crime books. I bet you would blow John Grisham out of the water and narrate the audibles. You know, thank you for that. It's a nice thing. It's a nice thing to say. I will tell you, I've actually thought about it. I've had a couple ideas that I've tossed around in my mind. Some of them for quite some time. Like, I have some ideas about like how to structure a book that I think would be kind of fun. I've just never, you know, taken it to the point of really sitting it down and like outlining it and blocking it out and all that stuff. I don't know if I should tell this story because it's not necessarily mine to tell, and the person I'm telling it about is sitting there at home in the moderator seat. But certain person that I know not too long ago, like a couple of years ago, there's apparently like a thing, I guess, that some writers do where it's just kind of a common resolution over a year to work on your book. And there's like all kinds of things in place, like supports and just tools, communities, things to help people out with like the year to write your book, you know. So I've considered I should really do the year to write your book, because the issue I have is that a book requires so much focus, and I have a lot of my attention is a bit scattered right now, which is kind of how I like it, you know. I like having lots of different interests and kind of being able to play with them and stuff, and finally having really the opportunity to see what really sticks and see what my, where my passion really is. So I feel like on some level, like if I had a passion for writing a book, I would have already done it. It would have happened naturally, but I reckon I haven't really tried it. So I do think about that. Thank you for that suggestion. Windy to be. Thanks, Andrea. Well, thank you. You are very welcome. Theory neutral. Say a child is killed and she has time-stamped video of some guy on her phone. As police, do you A, release to public ASAP for help, or B, bury it? Oh, man. It really is mind-boggling, isn't it? It's really mind-boggling how they've handled this. Just the very select stuff. Like, I understand perfectly well. You don't want to give out all the details and stuff. You need to keep some stuff close to the vest. But when you don't have good leads, you just don't know where to look. You gotta share the stuff with the public. That's the only way. That's the only way you're gonna generate ideas. It's the only way you're gonna maybe be able to trigger that, oh yeah, I saw, and the one out of, however many thousands that is actually the right one, I actually really did spot something that could be the thing that cracks the case. It's sad. It really is sad. Gen X girl lawyer with a super sticker. Hey girl, you're like my kind of people. Theory neutral. If not already done, can you walk us through this mystery video taken by Libby? Does the voice appear to belong to BG? So you can't tell. I'll walk you, like the regular video I mentioned when we saw it, the straight raw video. It is very hard to see everything because most of the time the phone is pointed down. It's like moving around. It's just like, moves up shortly for very short periods of time. So this enhanced video that they showed us today, you can see a lot more. and like to such an extent that I'm kind of like, I really do want to look at them side by side. Of course I can't because we can't get the exhibits, but I would love to see them side by side just because I'm skeptical. Like we saw so little on the first one and we see so much on the second that it's hard to reconcile that without, you know, without me coming to the conclusion that like, is AI involved or something, or like predictive? Like, are there things going on here that are filling in the gaps? Because you just really do not see very much on that first video. On the second video, what you see is you see the phone on the ground, and then it turns up and it points at Abby. Abby is walking across the bridge, and then you do see, like, at one point, like, first they're kind of like this, and so then as it changes, you know, the perspective changes, and you can start to see Bridge Guy, and he's behind Abby. So Abby is then walking forward. The camera turns back towards the opposite direction, like towards the ground where the trail is. And you then see the red shirt, the sweatshirt that Abby is wearing, and the jeans running past very quickly. And then the video kind of points back down. It's staying pointing at the ground and like in the area of the trail. And you just hear the voice. You just hear the voice. You don't see like where the voice is coming from. You don't see Bridge Guy approach. Like Abby comes running up. But you don't hear like thunk, 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 you know, heavy footsteps on the railroad ties or anything like that. And Bridge Guy is still fairly far back. The other thing that I remember from the first video, and it's, you know, memory. I'm not going to say that's the problem. Memory is unreliable. I feel like I saw towards the end of the video, after Abby runs past, because I noticed the clothing. I'm like, okay, that's Abby, and she's running past. And I saw the camera moving, and it seems like I saw a gray sweatshirt. Now it could be Libby's. If Libby was wearing a gray sweatshirt, it could have been Libby's. Could have been that Delphi swim sweatshirt. Because you know, I'm not gonna say, oh, there's a third person. I don't know. I just, like I'm saying, I feel like I saw a sweatshirt that could have been Libby's, but could have not been Libby's. So very hard to say. The voice. It's hard to attribute it to anybody. You can't say because he's not visible, and the camera is not pointed in the direction of where he was. So Nicholas Farmer, is the time at HHS real time? 127, wasn't it fast? 127 is the corrected time. It was fast by 54 minutes. So when they testify now, they are using the corrected time. So they did establish that back when they first brought those video stills of the other cars from that video into evidence. Sarita Banana, for your Oscar-worthy rendition of Tony Liggett's feigned outrage. Also, you and all courtgoers produce a mockumentary-style film based on this real-life trial. Who will play Gull? Oh, my Lord. Who would play Gull? I don't want to say, man. That's such a rude thing. I did make a joke today about I should write the Delphi diet cookbook. That could be fun. I could write the Delphi diet cookbook, you know, give some recipes, you know, some stale bagels and 101 things to do with cold stale coffee, you know. Preferably with 2 hours of sleep. Maybe I'll write that cookbook. Sweet Bee Me. Richard Allen was arrested 10/26/22. Carroll County elections were on 11/5/22. Liggett and McClelland both ran for office. Based on the state's prosecutor, the judge, something is rotten in the state of Indiana. Yeah, I mean the timing, I can see the timing being concerning. I remember, we haven't heard anything about it at this trial, and I don't know if we will, and I don't know if it's even true. It's one of those things I remember reading somewhere that supposedly Mr. Liggett had commented about how he was going to, or maybe it was the predecessor. It was Lesenby, how he was going to arrest. He was going to make an arrest before his term was up. Is that true? Can anybody verify if that was the case or not? Because that's alarming. I mean, that's alarming. That's a little too close for comfort. Freedom Ring. At end, if you have time, can you explain why lack of 2017 phone harms Alan? Don't we all trade in phones to get new ones? The problem is that if he has all of his old phones and the only one that's not there is 2017, that looks suspicious. It looks like, he got rid of that one for a reason, because he didn't get rid of all these other ones. You don't need your old phone anymore. It makes it look more selective. And so the making it look more selective makes it look more like that is a consciousness of guilt thing. I know there's evidence on it. I better get rid of this one. All my other ones I still have. That's why I think the absence has the potential to make Mr. Allen look bad. I think after today, the defense has raised the suggestion that there may have been some change of habits with how they do phone trade-ins or something like that. We don't know anything about all these phones. Ms. Auger, made a point of pointing out there's pagers here. So a lot of this stuff is old. It could be these phones are all prior to 2017. And if that's the case, then that's less alarming to me. I can reconcile that. It would be like if he's got all of his phones from before, all of his phones since, but not the phone from 2017. That's just what would look bad. So there are circumstances where I think that could be fine. These are all just old phones. He's got a reason for hanging on to these, but not for more recent ones. Yeah, I could see that. I could see that. Wendy Rubin with a super sticker. Thank you so much for that. Wanda, I said Wendy. Wanda Rubin. Thank you so much for the super sticker. Lisa Setzer with a super sticker as well. Thank you for that. The crypto tax lawyer. I love your laugh, AB. A sunny moment in this mess. I've always had the perspective it's served me well in public defense, because a lot of this stuff, it will make you cry. It will make you cry. The just absurdity of it, the awfulness of it. And so I always kind of envision those Greek masks, the tragedy and the comedy, the laughter and the tears. That's really been a big part of my approach to the law and to my practice. You just have to find the humor in things. You really do. It's one of the reasons why, ironically, like a lot of the times, I really do get along well with police officers. A lot of police officers, we have a lot in common. And police officers, a lot of them have that same tendency. Just you gotta find the humor in these really dark situations. So it keeps me sane. It keeps me sane. R&M Productions. Andrea, thank you. We love you. Why can't they show a literal video of Rick's interrogation? It's a double homie trial. Well, if the state doesn't want to put it in, then it's not going to come in. For those reasons I explained, they'll object to it as hearsay, and that will be sustained. That will be sustained. They will argue rule of completeness should allow us to bring it in. If you're going to cherry pick little pieces of it, we should be able to show the whole thing. And Gold's going to say, nope. Nope, I don't think it's necessary, reasonable to put that in context. Not needed. No context needed. That's what I predict is going to happen. Judy E. with a straight super chat. Thank you for that. Theory neutral. Sounds like those gloves fell into the wrong hands. The gloves fell into every hand pretty much. The gloves. Oh, the theater. It happens every single time. I swear it happens every single time. And you know, again, to me, it's the point where I laugh at it. But I wonder if anybody else notices this. And then I wonder if that, if they draw what I think would be the reasonable inference that if you handle the evidence like that in here where everybody can see you, Lord knows how you handle it when nobody's there to monitor and to check it out, to call you out. If this is the best you can do, who knows? Who knows what is going on with this evidence behind the scenes? Trendy views. So what I'm gathering so far, hashtag Richard Allen has actual superpowers. He can teleport, move very fast, control two people his same size, multi-weapon wield almost flawlessly, and disappear before your very eyes. Let's not forget he can shapeshift. He can also shapeshift. He is. None of us knew this whole time. Michael Osbrook, due process will save Rick. Have faith, guys. I sure hope so. I really do. My biggest fear at this point is just that, he gets convicted, and I think he's got an excellent chance on appeal, but it's just the time that it takes to go through the process. Justice delayed is justice denied. This is, a saying that's very important for a reason. He is paying the consequences every single day. If he is an innocent man, every single day that he is not exonerated and not free, he is paying the consequences. And it's just very difficult. It's very difficult for anybody to hold up under circumstances like that. And so it just, I know a guilty verdict would be devastating. It would be devastating. And it's just very easy to lose hope. That's what I'm concerned about. I'm concerned about them losing hope. I can fight the system. That's my job. I've been doing that for years. And, have some faith that somewhere along the line, somebody will get it right. But it's just the time that it takes. The longer it takes, the less just the result is. Analytical Blarney AB, thanks so much for all you are doing. Appreciate you. It is my pleasure, and you are very welcome. Lee Zecca, thanks someone great for the membership. Who owns a licensed insured Mercury Comet? I sure don't. I can't even remember the last time I've seen a licensed and insured Mercury Comet. I've been to a fair number of car shows. I mean, like I said, I'm not like a super car person, but cars are kind of cool and car shows are kind of fun. And I like looking at the different things, and yeah, can't be a lot of those out there. They got that description. Wonder if they ever looked up Mercury Comets. Any registered owners of Mercury Comets anywhere in the state? Why do I doubt that they did? Daylily Wellness. Do you think Anthony Shots / Snapchat will come up? So far, I think no. I don't think it will, mainly just because we've already gotten into the stuff with the extraction from Libby's phone. And so if there was anything that would, the connection to Anthony Shots would be on that phone, it seems like that would be the time when that would come out. Now, might be in the defense case, potentially could be in the defense case, because we've heard this foreshadowing possibility of deleted items can be recovered. And I would suspect that the defense has their own cell phone forensic expert. So potentially, maybe they were able to delete recovered things that the state's analyses were not. Maybe. I don't know. It's possible, but I think at this point, if it does come out, that's going to be how it is. It'll be in the defense case. Part of the reason why I'm skeptical is because it is just getting close to that third-party culprit stuff. It's getting close to it. All that got thrown out. None of it gets to come in. That in particular is a little troubling to me, just because of the proximity, the time proximity to the murder. Regardless of whether we're bringing this up to just, to point the finger at somebody else or whatever, just the fact that this was part of the picture of the hours leading up to those murders, it kind of seems like it matters, you know, puts it all in context, totality of the circumstances and stuff. But I don't know. Sarita Banana, less than 5K to get to 100,000 subs. Go, Andrea. I just saw that this morning. I was like, when did this happen? When did this happen? It's really blown up the last few weeks. Thanks all of you for coming by and for subscribing and joining in and being part of the scene over here. We do like our scene over here. ASMR law chat. Gingy Probs, just subscribe to your Substack. So grateful for all the excellent coverage. I'm from Mississippi and I'm not surprised by judicial nonsense yet. Yeah, you feel us. You feel us. I don't know why it tends to be rural, like small rural jurisdictions that are more like this. I mean, I don't. A lot of new people on the channel. If you haven't been around for a while, we're not super political here, right? I find it a very, it's just not a particularly useful way to categorize people most of the time, because people are individuals, and I think the reality is that most people's politics are just a product of your parents' politics and, you know, the politics of the people around you. But the things that actually matter in terms of character and personality and stuff like that just don't have a very strong relationship to who you vote for. So I know that's like the obvious distinction or conclusion that people will often draw. Well, the cities or the urban centers, they're more blue, and the rural areas are more red, and that you know, that's the explanation for it. I mean, I can't say that's not the reason or that doesn't contribute, but it just, I don't feel like that's fair. I just don't feel like that's fair. I've had very good juries in rural, you know, conservative jurisdictions. But it's just something about the structure of the community. I really just feel like there's something cultural in smaller communities that's very different from city culture, and that it's something in the culture that tends to produce just more of this. I don't know if it's the rush to judgment or if it's just the faith in the authorities. I feel like maybe in a small town, because everybody knows everybody, it's more of a high trust. You know, the city is notorious for, you walk down the sidewalk and people won't even make eye contact. You know, you try to say hi to somebody in New York, they're going to be like, what the hell is the matter with you? You know, small towns are different. You know, you might know the judge. The judge might be your kid's softball coach. You know, the police officers, they might be people that you go to church with. And so I think there might just be a little bit more of a tendency to trust the authorities and their decisions and their opinions and their conclusions and stuff, and not really question it like you would in a situation where you don't have those relationships, so you don't necessarily have a reason to put a lot of faith in the people that are doing the prosecutions. So that's my thoughts on it, but I don't know. What do you guys think? HP, I've been watching you since you were on the fallen YouTuber I won't name, but I think I should finally tip you. Well, thank you for that. Thank you for that. I'll go. You know, I haven't talked about Nick Rakita, and I'm not going to. I'll just say I really enjoyed being on his channel. He's pretty much one of the reasons why I'm here. I think it's a real shame, you know, to see where he's at right now. And, but I wish nothing but the best for him. That's all I'm going to say. John Doe with a super sticker. Thank you so much for that. Really appreciate that. Felicia, can the jurors ask the questions that the defense couldn't? That would be funny if they tried, wouldn't it? I would kind of like to see them do that. You know, these question gets objected to and they come back and they have to move on. So it's really clear that the objection has been sustained. The judge just won't ask the question. The problem is that if she said it's impermissible for the defense to allow it, she's, you know, making a decision that the law does not allow that question to be asked. So she wouldn't allow the jury to ask it either. But they would see that they're asking it, and she's not letting it go through. That would be kind of fun if they tried it. Gingy Probs. Is it possible the court's disdain is because she's unfamiliar with folks like you and Lawyer Lee? Maybe she thinks sensational citizen sleuths. I'm reluctant to assume corruption, but if it quacks like a duck. I have to say, I mean, I understand why this community, Moscow, had a lot of the same issues. I understand why they may have some negative reactions to some of the YouTube and the social media activity that goes on with these cases, because while I tend to think that most people are well behaved and most people are well intentioned, not everybody is, and it can become aggressive, you know, accusatory, and that's not helpful. That's not helpful. And so I can understand very much some blowback against some of those less positive tendencies, with just the attention that's brought to cases like this. Obviously, that's not what I'm trying to do, but I don't claim to be perfect. I do try to be respectful. I may make mistakes. I try to take accountability for my mistakes. So if I do make a mistake, you can let me know. But I just think, for whatever reason, she is just decided that we're not entitled to see it. That we, the public, it's not our trial, it's the family's trial. And we shouldn't get to know the details. We don't have a right to that. And so she resents us for being there. Like we have a right to do, a legal right to do. She knows the boundaries well enough to know she can't close the courthouse doors and keep us out. That's not going to happen. She knows that is not going to be tolerable. But she does. She's making it clear that she resents us, and that where she has discretion, she is going to exercise it in the way that makes our attendance as unpleasant as possible. And that's, in my view, to discourage us from being there. She wants us to give up and quit and go home. Well, she hasn't met me. So I don't really take it personally. I really don't. I think it's just part of the overall attitude that she's had, that she's kind of done with all of us and our interest in the case, you know? That's my read on it. Rochelle D. Muddy Bloody walks to his car at the old CPS and suddenly all the DNA falls off before he gets in. You guys kill me. You're speaking my sarcasm language here. It's crazy, right? It's crazy. I mean, I find it hard to believe. I don't know what they did to the car. I'm sure at some point we're going to see what they did to the car. I expect they've torn the car apart. Frankly, I don't want to say I hope they've torn the car apart, because, you know, it's Allen family's car and I feel bad for them about that. But it would require tearing the car apart to be able to investigate, you know, the feasibility of recovering DNA from something that happened 5 years ago. But yeah, especially one of the things I was thinking about too, Sarah Carbaugh, you know, she described the blood as being at the bottom part of his jeans. So it's his lower part. It's on the bottom part of his jeans, probably on his feet. And he's going to be getting that on the carpet in his car. And the thing about the carpet is it will seep all the way through. And so I expect to go in, I expect to see carpet torn up, I expect to see the dash taken off, I expect to see the seats taken apart. I mean, that's what I expect to see. If this is a thorough investigation, that's what I expect to see. because that's what it would, potentially take. And if they had done that stuff, and if there was DNA, yeah. I mean, 5 years is a long time, and DNA does degrade, but I was trying to remember now because I forget. I had seen it a few months back. Like some of the oldest DNA that's been recovered just out in the environment is like several thousand years old. Like it can degrade. It doesn't always degrade, and conditions can help preserve it. So like if it's not out in sunlight and stuff like that, temperature extremes aren't helpful. If it's sunk down to the frame of the car, the frame is going to get hot and cold. It's going to get condensation and stuff like that. Maybe not such a great environment for DNA to be preserved, but they better have at least looked. They better have at least made a serious effort to look and not just gone in there and swabbed a couple parts of the steering wheel or something. That wouldn't be good. Pantoufle, Sarah Bareilles will play you, but even prettier. I'm going to have to write that name down because it's not one I am familiar with. Let me write that down. Sarah, Bareilles. I'm going to look her up and see. I'm not going to tell you who my husband thinks my celebrity doppelganger is because it's somebody that nobody likes. I don't dislike her. But, it's like, why that person? Cheryl Baber, based on why Liggett said he heard on the audio, do you think the girls were there to meet someone? I don't know. I didn't necessarily get that impression. I mean, it sounded like his interpretation of it was that, they had noticed Bridge Guy, and Libby starts filming, and Abby is commenting about Bridge Guy, and then Bridge Guy approaches them, and they interact with him. That's pretty much what it sounds like from his interpretation of that video. I can't hear it clearly enough. I could barely hear part of what Libby was saying, where she was saying there's no trail here. So I can't say that's my impression from the audio, that they're there to meet someone. Might be other reasons to think that, but I don't think this is really helpful for that. Lori Lee Annie, I subbed on your very first live. Go, Andrea. Well, thank you. My very first live, when I just decided, kind of spur of the moment, hey, there's a Koberger hearing, I should stream it. I'd never live streamed before. I'd only done like the pre-produced videos. My husband, the lonely mod, helped me out, and we got it done, and look where we've come from there. Thanks for being there with us. Scott Kendall, I have every phone for years except one I gave to my son to use as he was old enough to use them. This is nothing. That's a really good point. I hadn't thought about that. That you might give your phone to one of your kids or something like that. Yeah, that's a good point. The other thing, the other thing I thought of too is that, do you always keep the same provider, or do you change providers and stuff like that? I could see that having to do with what phones you keep and what phones you don't. If I'm sticking with the same provider, maybe I'm more likely to just trade in my old phone and get a new phone. But if I'm going to switch providers, I got to get a whole new phone. Maybe. I don't know. But I think that's a very good theory there. Good possibility. Just gave it to somebody who needed a phone. Carazola X, the judge just seems like one of those people who, once they feel slighted, they will never, ever, ever, ever let it go and pursue infinite retribution. Yeah, there's a name for those types of people. I'm not going to use it because it's a little bit overused. But yeah, we can get vibes. We can get some seriously vindictive vibes, some punitive vibes. Yeah. Well, the thing about hate is it really just poisons the person that's feeling it. It does nothing to me whatsoever. She can hate me. It's her problem. That'll just make her life miserable, and it won't affect me at all. And we'll continue to stay here doing what we're doing, having our good time, watching the trials, trying to get public access, trying to get justice, trying to see that it's done, trying to see that everybody gets their eyes, or at least their ears, on what's happening in this courtroom here in Indiana. That's it, guys. Not as late as last night, but still a little bit late. So I am going to go ahead and check out now, get my sleep. I might get a whole 6 hours tonight. I can't wait. That's just going to be like new life flooding back. So thank you again, everybody, for being here with us. Thank you for all of your support, all of your nice comments, all of your good questions, all of your great ideas. I love these ideas that people have. You are so creative. You think of things that I don't. You expand my brain, and that's like my favorite thing to ever happen. Just make me think harder. I just love it. So I owe that to you guys. I can't do that on my own. You know, on my own, I just am stuck in my own little framework for thinking about things, and that's what I love about having opportunities and communities like this, and a chance to put our heads together about things. Sky, thank you so much. Thank you. Thank all of you. Really appreciate you. Thank you for being here. I will be back. Cross our fingers, continue to have no problems getting into the courtroom, continue to deal with the chaos, get to bring my lunch now, pray that that continues, don't have to starve. But so far so good. I think we're on a good track. Oh, before I forget, we do have the notepad count to get through. So I already almost put it away. Today, almost a full notepad. Let's see, once again, probably about maybe less than 10, maybe we're more like 6, about 6 pages shy of a notepad. So I'm really on track to be, roughly a notepad a day. I suppose maybe by a couple weeks, if I count up all these 6 pages here, 10 pages there, and stuff like that, we might subtract a notepad from the total, but 8 notepads is where we're at so far. And yeah, I guess one of them's only about a half notepad. Oh, maybe 2 of them are about half notepads. So we'll round that to 7. We've gone through 7 so far. Not bad. Not bad for 9 days of trial. It's just been a lot of stuff. A lot of stuff to get through. A lot of details to try to keep track of. So with that, guys, I am off, going to get my sleep and enjoy it thoroughly, and look forward to meeting my guardian angels in the morning. I'm so grateful to everyone who has, they literally decided on their own. They just took it into their own hands to volunteer, to organize, to get everything set up, because I don't have time to even think about it, let alone like deal with it. And I feel like I've been blessed. Like my angel from heaven came down and has made this sustainable, made it possible that we're going to be able to continue bringing you these details about this case. So it's just a wonderful blessing we have here. So grateful for so many things. So happy to be here and to have all of you here with me. And I really look forward to seeing you guys all again tomorrow night after we get through day 10. I will see you there.